May please, my lord. We are filing the application. We are filing our written submissions, as per your lordship's kind directions. Only one small, may please, my lord. I've added an annexure, by which you've shown now submissions, that it is not just, one party, Rashmi Metallics, which I had argued before your lordship, which they finally did on the annexure. They have actually, you've shown now submissions, that it is not just, one six Rashmi Metallics, which I had argued before your lordship, on the 11th, finally did on the last day. And out of those, your lordship will find that 16, serial numbers 1, 6, 16, 7 to 13 are all major minerals, identically situated with us. Manganese ore, iron ore, serial numbers, bauxite, etc. So now it's absolutely irrefutable, identically situated that the state picked and chose.
You have narrated all such facts in your written submission.
Everything.
No difficulty. We will take it
Deeply
into
grateful.
consideration.
I'm deeply grateful to my lord for a very patient hearing.
Yes, let the written note of submission filed by the petitioner as well as the state. No difficulty. We will take it.
Most grateful.
What about 2? Withdrawn. 2 is withdrawn?
Withdrawn.
Yes. 3.
Item number 3.
Most grateful.
What about 2? Withdrawn. 2 is withdrawn? Yes. 3.
Item number 3.
What about 2? Withdrawn. 2 is withdrawn? Yes. 3.
Item number 3.
Annexure 7 you have challenged.
Withdrawn. 2 is withdrawn?
Annexure 7.
3.
Item number 3.
Annexure 7 you have challenged.
Withdrawn. So they have said already.
Annexure 7.
Item number 3.
Annexure 7 you have challenged.
Sir, there was a demand. It says that this demand is long outstanding. Please pay. They gave you another lease of life, I must say, to pay off. It says that where is your document receipt? They gave you another lease of life, I must say, to pay off. Then that is a mistake on their part. Please show us that you have paid. Annexure 2. The same amount?
Same amount.
No, you have paid more.
No. Royalty plus penalty. The royalty is
No, they may have made a demand of 1,18,750.
yes.
And this receipt is showing 1,43,000. So more.
So they are omitting penalty. I have paid 1,18,000.
So you are so benevolent that you have paid the penalty instead of their demand. Now, madam, if it is paid more, I think you should be happy to accept it.
It was 30 lakhs.
Well, you are.
He has represented.
Oh, Annexure 4.
Whatever.
No, Annexure 4 is 30 lakhs. Now, why
He's
is this
challenging 7 only.
The other amount he has paid, your lordship.
He's challenging 7, Annexure 7. So he has paid more. If others are due, then they will raise a demand.
Another, excuse me. The period which was I was directed to stop operation has not been extended, and I request the police paid.
For the same amount. Just look at Annexure
I have
2.
seen.
You see, na?
Only penalty is difference.
difference.
That 25,000, that is penalty.
They have also paid.
So only
Madam, then what remained? Annexure 7, if you come, you have demanded 1,18,000.
Your lordship.
Nothing more than that. Please come to page 27. I have to take up his brief to make you understand. Please come to page 27. What is the amount you demanded? Correct. Come to page 11.
He shows that he has paid it.
Please. The same amount you will find here and then the penalty.
So the officer,
This demand is wrong.
the officer who has given this receipt may be en route. So he has not communicated it to the proper authority. So that's why this remand.
In that meantime, the lordship, it changed from to the seal and mines department.
Whatever, then you should. The demand cannot stand. So it has to be quashed.
In the total of 30 lakhs, 19,000.
Sir, we do not want, your demand was, you said that if you, unless you pay within 10 days, then it's all right. If you do not pay, you certificate proceeding. Now it shows that he has already paid before that.
19/8/2023, Your Lordship.
That is what I'm saying, and he has
That
paid
is
in
what-
2020.
No. What she is saying that this demand is raised in 2023. What is his prayer? He has furnished one annexer 8
Yes, Your Lordship.
representation in 2024. You are not considered. That is what he is saying.
Yes, Your
So that's why he has come. So you have to take instruction to say
What is that?
whether
Brother, don't keep it. It is an open and shut case, because had there been any other demand, I can understand. But this demand pertains to this, and that is the cause of action. Other demands, proceed. If there is other demands, then you'll have to claim. Sorry, you can't. It is really a sordid
For non-payment of some dues, my operation was stopped for 1 year, 2 months.
That you have not prayed here.
Represented. I have represented, and that is part of my prayer. So that may be considered. And sir, it may be considered so far as extension of leave period is concerned.
Can they extend?
If they don't, other
Do you have any provision in the rules or the act which permits the extension? You are entitled to compensation for their action. That is the different issue. But can we direct a mandamus upon the authority to do beyond the law?
for the reason of.
That is the whole problem with me, sir.
Stop.
Consideration of representation theory is I'm very conservative in this.
Oh,
Show us your right, we will definitely grant you a right here. Anyhow,
Item number 4.
it is open to you to consider the representation.
that one line will suffice.
Oh, one line. Then.
Item,
Because now you have to go to Steels and Mines. That was before Tahsildar.
Yes.
Well, it's a sequel to.
4-9, where is the letter, show cause notice, letter 4-9?
Let me first tell you that it's a sequel to your lordship judgment. That in home transport, that's just recently, 28th of November 25.
We don't remember the name, we remember the principles which we have decided.
Remind your lordship. That is that IOCL cancellation of NOC matter, which your lordship has very recently delivered. Because of cancellation of NOC given by IOCL, SPCL has issued this so-called notice to cancel my LOA. And that NOC
The same.
cancellation has been set aside by your lordship in that day. So therefore I say it's a sequel to your lordship judgment in a home transport matter.
So we have said that you cannot, because that does not come within the purview of that clause.
Right.
In this new higher
They wanted to submit
tanker.
It is that you wanted to provide a better vehicle
with IOCL.
and release the older one
Right.
so that you can participate in another tender and can place those.
Yes.
This is that matter. Yes.
That another tender is this. That another tender is this man. Let me remind your lordship about the facts. This HPCL
This is listed first time.
No. That batch of petitions which were argued, I think this was the main matter which was argued. I was just trying to
No, Bilal. Let me tell you.
record all the submissions.
No, this has come for the first time.
No, this may be.
Yes. So, Bilal, the short question is this. What is, Bilal, your lordship knows, in common cause, a judgment delivered, my lords, in 2017, 9 SCC. My lords are kindly pleased to come to Annexure 7, page 60. Lords.
Age?
Page 60.
Yes.
2 questions were decided. That your lordships will get at page 119 and 120. That is para 96.
119.
119, Millers.
Yes.
At para 96.
Page 119.
Yes, Lord. Page 119.
I do not find
Oh, one of the
119.
writ petition, Millers. 126. What? My lord, sir.
Actually,
Judgment
the
begins.
difficulty is that I got confused because of one page having been incorporated.
Oh, I'm so sorry. Indeed.
Actually, this is 118 I was going,
Oh,
and then the 60 comes, so I got confused.
I'm so sorry.
But then 119 is the next page.
just before 60,
Okay.
118 has come.
I'm so sorry. Can I give you
No.
Can
That's
I
the
give you
confusion is over. Confusion is not there, don't worry.
Lord, 2 things arose for
Oh,
consideration.
yes. Which one? 119?
Yes, Lord, now at page para 96.
Yes.
Let me tell you, Lord, what was the issue.
Pencil.
Lord, in the state of Orissa, there was a lot of production of ore in excess of EC and mining plant. So the matters were referred to not the CEC, the Central Empowered Committee by the Supreme Court. The Central Empowered Committee said that EC will be the base, environmental clearance. If you produce more than that, then you'll be liable to pay a 21.5 penalty. The second question which arose for consideration is what is the cutoff date? From which year it will be effective? If your Lordship sees para 96, kindly see Roman 6. Your Lordships have Roman 6, no?
What is this SPCB?
State Pollution Control Board.
Okay.
My Lords may kindly
Just
see Roman 6.
let me read all the conditions.
Let me read it from the beginning for you, Lordship.
No, I am reading it.
No, let me read it first.
Oh, I can read faster than you. Don't worry. And it really saves
Yeah.
so far as the existing one is concerned.
What it says
And it is prospective, anything which is after this judgment.
2001. The cutoff date is 2001 onwards, you pay. And that your Lordships will further get lots. At page 138, see their conclusion. Paragraph 157, page 139. My Lords
Yes.
have para 157. Your
100% compensation.
Yes, and the cutoff date is 2001, as discussed earlier. So therefore, Lords, what they decided is, you pay EC over and above, the cutoff date is 2001.
AEC? Well, it is
Production in
often.
excess of EC.
Acha, that is what is.
Grateful. Now, my Lord, kindly see what the state does is, Annexure 11,
Page.
page 229.
Yes.
Now, may I read this? And whereas it has been observed that so-and-so mines over an area of so-and-so, let me leave there. Kindly see para 2. And whereas pursuant to the interim order dated so-and-so of the Honorable Supreme Court in the matter of so-and-so, common cause was in of others, the CEC has dealt amongst others the issue of production without in excess or in excess of EC and has submitted a final report on 16/10/2014 before the Honorable Supreme Court. In the said report, the CEC under para 34 has calculated the notional value of the total quantities of iron ore and manganese produced without EC, beyond EC, by all the lessees in the state of Orissa during 2001 and 2010 to 11. Kindly note these two dates, 1 to 11. The details of year-wise production of iron ore, mineral by so-and-so, mining leasehold area, along with approved limit of production of under EC, in excess of production of the mineral and the notional value price of minerals, total quantities of iron ore mineral produced without EC, beyond EC by you during the years 2001 and 11 have been indicated in the said report is annexed herewith. So, saying, Lords, they raised a demand which I duly complied with. They raised a demand that your demand was at page 232, Lords, which I complied.
230, they say,
Yes.
28 crores.
Correct. This is all paid.
Yes.
Now, what happens is, Lords, prior to the judgment of the Honorable Supreme Court, a demand notice was issued to me on 1st of February 2013, that is page 39, annexure 5.
Yes.
Now, kindly see this. Payment of cost price, your Lordship's receipt is 6.98 crores. Kindly see the period 94-95 to 99-2000. So this is prior to the cutoff period.
True.
So this was a demand. And after I paid that, nothing was happening. I also took it that this is all closed. Now, in a counter affidavit filed in a collateral proceeding before your lordship, and that your lordships will kindly see at page 62, 162 annexure 9, in an affidavit filed in 2025.
Yes.
My lords are kindly pleased to come to 176. Roman 4. And this is an affidavit filed in 2025.
One.
Case now say
No, no,
Roman
160.
My lord, 176.
176.
And written.
Yes.
Now they say rupees so and so, 6.98 crores, is outstanding against the lessee, Messrs. So and so, demanded towards unlawful extraction or firing over in Gorumasani Sai Iron Works for the period 94-95.
But that payment has already been done.
Exactly, that's the point.
But this payment has already been done.
This the cutoff date your lordship saw was 2000.
No, that is there. That after 2000, 2001,
Whatever
he says that the EC, whatever, that will be done. Prior to this, if they have raised a demand,
that goes.
then in that event, if they have quantified the demand, then
Yes.
this quantification has been paid off.
What was paid is 2000 onwards. Because the cutoff date your lordship said, Supreme Court said.
No, this
That 11 years
payment.
period.
11 years. Yes, that is paid. No difficult. My
No. You were referring to this particular document of 6 lakh something at page
Yes.
39.
Yeah, let me show that to your lordships
This
again.
page 39 is a 2013 demand.
Yes.
And then you have said that I have paid this amount.
No, what I said is
I just accepted that. You said that we have paid off.
No,
So I thought that you have paid this amount.
kindly see what I have paid. What I have paid is
That no, you orally said I did not go into. I have seen what you paid was from 2000 to 2011.
yes.
I understand. But
Correct.
when you refer this 39, you
Yes.
said that you have paid
No,
off.
I did not pay
Oh.
because it's not required to be paid.
Now, that is the question.
Yes.
That is the question. Whether you should pay or you should not pay.
And my Lord, Supreme Court says 21(5) penalty is payable from 2000 onwards. Number one. After the judgment, my lords, they pass an order saying from 2000 to 2011, this is the amount you pay, have paid. So therefore, can you now say that you are liable to pay for a period prior to 2000?
If you have made an excess, the extraction of the mineral or
Yes.
the ores.
That is why the Supreme Court took a view that for the past period, you are not supposed to pay. Would you lordship
I
see-
do not know the Supreme Court in such very
Would your lordship
categorical
see-
words have said.
Let us-
It says that of 2000 onwards, you have to obtain the EC and then proceed.
So kindly come back to the Supreme Court judgment.
Please, I have not read the book,
Sir,
but that's the impression I get.
Lordship may see para 156 at page 130.
Yes.
Let me clear this doubt of it.
Let us see, because I have to read the whole of the judgment to understand.
56 minutes.
Just give me a
Yes,
little
please.
bit breathing time.
Absolutely.
You have to read the judgment. I have seen 156.
Yes.
The court has discarded because there was a recommendation
I'm
given by
grateful.
amicus.
I'm grateful.
But why it is not accepting?
Yes.
What is the meaning? I think
No,
this
it's-
relates to a penalty of the 100% on you if you go beyond the
Yes.
the quantification done in the EC.
Yes. What they say
So,
is.
but what about the price of the royalty which is there or due prior there?
Royalty, it's like this. Let us first deal with the 21.5 will then come to it. Now, my lord, 156 says,
Have you read the whole judgment? I have not read it.
well, let me explain it to you.
Just give me that
Yes.
7
Okay,
minutes time. 7 minutes time. Let me. Doubt.
Yes. So what I was saying is,
Yes.
that in this judgment,
Uh,
the cutoff date was fixed from 2000, 2001.
what for? Cutoff date was fixed for what?
For EC. So what they said was, can you see 156 again? It was the submission of the amicus.
No, there are two aspects of the matter.
Yes.
I do not know this 6 crore relates to what.
Uh,
If the entire judgment which I have read is,
Yes, sir.
the contention was that section 21 of the MMDR Act
Yes.
that contains a particular provision, subsection 1 and subsection 5. Now, how to make a dichotomy in between that? Subsection 1 appears to be a criminal liability being attached to it.
Correct.
Subsection 5 was considered to be an independent of subsection 1.
Yes.
Now they say that yes, before the CSC or CEC,
Central and Part Committee.
you raised an objection that it should be from a prospective date that was rejected by them. Now what they say is between 1993-94, when there was a rampant, excessive or the extraction of the
Correct.
ores were there without any EC or without any clearance from the State Pollution Control Board. So all these things were happening. But then there was an EIA of 1994 which they took out.
Correct.
So EIA contemplates that what are the requirements and what is required to be done. This was summarized in that particular paragraph which you referred, that the no EC is required or something. Then it is substituted by the another 2004 or 2006 EIA. Now the dichotomy was sought to be created in between these two. It says that this EIA of 1994 is a mandatory in character. And it says that the EC overrides the binding plan. It is paramount.
Correct.
This is what the judgment, if I correctly understand. Then the judgment says that whatever the production, if you have done it, you are liable to pay the cost of the production during that particular period.
Correct.
You may not be penalized, or the penalty can be imposed by them, which would attract from 2000 onwards. But for the purpose of the cost of the ores or cost of the mineral or whatever, that you cannot absolve your responsibility. That has to be paid.
Then now let me tell you also. Straight up answer your question.
So this is what they have raised, that this must be a cost of the ores.
No, I'm coming there. I'm coming. But first is, these are all lessees. There is no dispute.
There cannot be ownership. It has to be lease.
No, because there will be some areas which are mined without a lease also.
No, then the distinction was there. It says that you can't go beyond that.
Exactly. I'll tell you. So therefore, once I'm a lessee, I'm not supposed to pay cost of mineral to the state.
Why not? Why not?
I'm only supposed to pay royalty.
Whatever is provided in the statute. Yes.
Let's get clear on facts. If I'm a lessee, I'm not supposed to pay the 21.5 penalty. Point number one.
No, there is some distinction within the lease area and beyond the lease area. That was also taken into consideration.
So we are all considering a case of a lessee who has mined within the leasehold area. So what he has done is, he has mined and dispatched the goods on payment of royalty. This is the first point. The second, the question which arose for consideration is that, look, since you have violated the EC, we will penalize you. This is the second point. The third point is, for violation of EC, there is a provision under the EP Act. That was what was argued. So therefore, where is the question of 21.5? In fact, the Parliament amended 21.5 post this judgment. But that's not the story. So here we are faced with a situation where admittedly I have done some production which is beyond my mining pay. The question for consideration was that the
relevant period.
Milord, I have the so-called the notice which is telling. So there is a period prior to 2000, there is a period post 2000.
Post 2000 you are.
So let's now see, Milord, what the Supreme Court was dealing with. Kindly see paragraph 56, kindly read with me 156. The submission made, can you let us read 156 together? It is at page 138.
Hmm?
A submission was made by the mining leaseholders. Your Lordships have it?
I'm looking at.
That the maximum production in the year 93-94 should be considered as the base for calculations. Such contention was also urged before the EC was rejected. We not have much on said that. We have examined these contentions independently, and we are of the view that the base year of 93-94 is most appropriate. So therefore, let's not go into that question. Kindly see the next one. We have already given the reasons. Some of the lessees might lose in the process, while some of them might find the benefit. That cannot be avoided. Now, this is important. In the event such mining leaseholders are given the benefit of calculations only from 2001 and not being penalized for the period prior thereto, because 21.5 is a penalty. Prior thereto, we think the leaseholder should be grateful for this, since it was submitted by the learned counsel for the petitioners, that is, the petitioner, PIL petitioner, and the learned amicus, that penalty should be levied from the date of EIA 1994. Kindly note, this date is 27th January 1994. So what is the argument of the amicus? And the argument of the petitioner was that this should be imposed from 27/1/1994. And your Lordships will get that date minutes of 27/1/1994 at page 116, para 86, only for completion. Your Lordship, nothing turns on. Let me read this line again. In our opinion, the cutoff date of 2000-2001 without interest is undoubtedly reasonable, and there can be hardly any grievance in this regard. The mining leaders, mining leaseholders, etc., we are not much on that. Kindly see the next paragraph. Since the recommendation of the CC
This is found to be somewhat reasonable, so 100% price
Correct.
from 2000 to
I'm ready.
2001.
Why 100% price?
But why can we ignore the paragraph 151
Yes,
of 150 and 151 of the judgment?
Yes, minutes. Yes, minutes.
Yes,
Yes,
we are in agreement with the view expressed by the learned Attorney General and Mr. Dwivedi, who was representing the state government,
Yes.
as also the view expressed in Karnataka RERA.
Is not at
The
all
decision is such and such,
There is
not
no
at all
ambiguity.
opposite.
Section 21.
That is, the Khemka was not opposite.
Correct.
There is no ambiguity in section 21(5) of the MMDR Act
Yes.
or in its application. We are also of the opinion
Yes.
that though section 21(1) is of the MDR might be in the realm of a criminal liability,
Correct.
section 21(5) is certainly not within that realm. Then
Correct.
151.
Correct.
We, in our opinion,
Yes,
section 21(5) is applicable when any person raises
Yes, minutes.
without any lawful authority any mineral from any land.
Correct.
Any land.
Correct. Correct. No problem.
Because the distinction was non-forest, forest,
Correct.
deemed a forest,
Correct.
three categories.
Correct.
In that event,
Yes.
the state government is entitled to recover
Yes, minutes.
from such person the mineral so raised or where the mineral has already been disposed of,
The price
the
thereof.
price thereof as compensation.
Yes. So
The
they.
words any land
Yes.
are not confined to the mining lease area.
Yes. Yes.
As far as the mining lease area is concerned, the extraction of a mineral over and above
Yes, minutes.
what is permissible under the mining plan or under the EC undoubtedly attracts the provision of 21(5)
Correct.
of the MDR Act, being an extraction without lawful authority.
Correct.
This would also attract section 21(1) of the MDR. So something is in excess of the mining plan
Will attract both.
is also
Correct.
coming with that.
Correct.
Then it would also attract, in any event, section 21(5) is certainly attracted
Yes, minutes.
and is not limited to a violation committed by a person only outside the mining lease area. Within also, this is also because of the MMDR Act is intended, amongst other things, to penalize illegal or unlawful mining on any land, including mining lease land, and also preserve and protect the environment. action under EPA or MCR could be contrary action, a primary action required to be taken with reference to MCR and Rule 1, Roman 2A thereof, read with the explanation. But that cannot preclude compensation to the state under 21(5). This is what I said, both within, outside.
Correct.
So that cutoff date was given only for the purpose of an EC.
Yes, my lord, we are only talking about EC.
But what about the extraction beyond the mining plant?
No, that was not. Kindly let us come back to. Let us
See,
come
what
back
also
to my
came
lords,
to
the
beyond the
annexure
mining
5, page 39. Let's
No, the description in the opening paragraphs were
Yes.
given that how many leases,
Right.
out of which how
Right.
many leases are operating beyond the leased area, demised area, or within the demised area. Everything is.
So one of the issues which fell for consideration of the Supreme Court is that whoever has produced in excess of EC, he will be liable to pay compensation.
There was no contemplation of EC in that. That's why I read it, paragraph 151.
Let us read 156 together.
That is different. That is why you have to make a synergy between these 151 and
Let us then therefore straight away go to the finding minutes. If your lordship sees what is the final decision of the court, kindly see conclusions at page 147. Kindly see, my lords, page 147. Conclusions on the issues without mining, without IFC or FC or both. We are concerned here only with EC. My lords, have it, my lords?
Yes.
Kindly see, my lords, 5.
Yes. Which one?
5 minutes.
5 of
188, para 188.
188.
There is 5 minutes. These are to avoid any misunderstanding, confusions or ambiguity. We make the following clear. Your lordships have that paragraph. Kindly come to 5 minutes. Any iron ore or manganese ore extracted contrary to EIA 1994 or EIA 2006 would constitute illegal or unlawful mining as understood and interpreted by us, and compensation of 100% of the price of the mineral should be recovered from 2000-2001 onwards in terms of 21(5). Let's close. This is the conclusion.
I have to just justify this conclusion with the other things, because there appears to be some kind of an omission.
Right or wrong? Right or wrong?
But the High Court can definitely interpret the judgment and understood. Because what I find is, I am reading paragraph 153 as well.
What is bothering your lordships may be, minutes, that this finding only applies to EC. Otherwise we'll be reopening the judgment, right? So far as EC is concerned, it's a fait accompli. And this judgment is 1997 minutes. Stood the test of time. 2017. I'm sorry, 2017. It's 2017.
Yes.
Now let us see, after this judgment, let us see how the state looked at this judgment. Would your lordship straight away come to page 229.
Let us hear this matter if you wanted. And 2013 demand. You are challenging a
Yes, yes.
2013 demand
Demand.
now. So there cannot be any question.
Why I am challenging 2013, the Lordship must know that. Now, kindly see, so far as I was concerned, there is a letter at page 229, post the judgment. Annexure 11, page 229. This is how the governments understood the judgment of the Honorable Supreme Court.
I understood.
Yes.
Now the question is, if it is a demand of 2013,
Correct.
you wanted to quash it after a period of 12 years.
I appreciate
There is no eminent emergent situation which requires an immediate interim protection to be given.
Lordship,
In that event, we will definitely hear out the matter. It is the first time it has come up.
correct.
Let them come. If they have taken a same stand in the other matters, I think they will take a same stand. Consistency, uniformity is the hallmark of the any.
Article 14.
That's the equality principles. Uniformity
If you
in the
don't-
factual aspect.
If you take different stands in different cases, it will be
It is a different.
show you Lordship.
That's not okay. So let them come. If you want to take it, you'll have to justify. You cannot resile from that particular stand which you have already taken
No,
in your counter.
my lord, this is judgment.
Counter affidavit,
Yes.
that writ petition was dismissed as infructuous.
How does it matter?
That-
But stand you cannot change.
Stand that demand always, because the
Stand.
petitioner-
The question is the stand. Factual stand. You cannot take a different view.
My lord,
So will you rely on that to avoid the disposal, or you like to file a counter affidavit reiterating the same thing?
no, my lord, we will file a fresh counter affidavit in this case, but
But
we are
at the risk of inconsistency, at the risk of repugnancy. You remember?
My lord, can they
kindly
state? My
consider
lord,
somebody
can-
has come before this honorable
Yes.
court
Yes.
after 12 years.
That is because you
Now,
prompted me to come after 12 years.
2017, even the judgment was delivered. Till then, there is a delay of 8 years.
Oh, we are keeping this matter for this. Now, interesting point. I just thought it can be disposed of, but I think it needs a clarification.
My lord, would your lordship
And I will
fix a
do
date
it.
in January 2? Fix a date in January 2.
The challenge is made to Yes, what is this?
Lordship,
Where is the order of the court on 20 in the month of August on
Lordship, that
18/8/2025?
that-
Where is the order of the court on?
that is my Lordship in page 20 I have quoted, Lordship, starts from page 20. That is regime order, Lordship, it's a fourth-round litigation. At the first instance, Lordship, and after this one, and Lordship directed to file appeal. And on second round litigation on the ground of jurisdiction, Lordship, and third round on the ground of limitation. And this is the result, Lordship. And the determination of this official.
So that was the judgment by us.
Lordship.
We have interpreted that when there is a format which is provided in the statute for the purpose of communication, then in that event that the state cannot absolve from complying or adhering that provision.
Lordship. Lordship, please come to Lordship Annexure 1 for a moment. Lordship, perhaps I want to refresh Lordship.
No, they have, who was the appellant before the authority?
Lordship, I was the appellant, Lordship.
You were the appellant.
I was-
Then you said that you do not have a locus standi, you can't be an aggrieved person.
Lordship, I am the agreed party, Lordship. My bid has been rejected. I am challenging from the day one. Lordship kindly come to Annex 1. This is the order of the appellate authority. And Lordship kindly see what is the finding of the appellate authority. Lordship straight away come to page 46. 46, Lordship. Lordship, please come to Lordship. Going through the orders of Tahsildar, Lordship, page 46. Going through the orders of Tahsildar Viromitrapur and documents found in the LCA, the following deficiencies are found. This is the finding, Lordship. I am reading from Roman 1, Lordship. Deposit of the treasury challan has not been properly scrutinized by the Tahsildar before going for declaration of H1 bidder of the source. Besides, the H1 bidder has also concealed the fact of non-deposit of challan as revealed from the letter number such and such of sub-treasury officer Birmat.
Yes, how can you take a technical plea and then they reject the application? We should decide it on merit. We should decide it on merit.
Decided on merit.
It is not. He simply says that he cannot be said to be an aggrieved person because in one of the matter he did not ask for quashing of that particular decision. But that was not. One has to whether he has complied, because if his bid is rejected on a technical ground when it does not appear to be supported by any fact, then
That's 7 years observed.
please look at it.
Page 89.
Yes, not 89.
Yield offered by.
No, not 89. 92 is the order.
Sorry.
92 is the order, is a subsequent order.
Reviewed order is at page number 92 to my lords.
Please come to page 90. Yes, you refer. Yes. 92 is the order.
Yes, ma'am.
If you come to paragraph 3,
Yes, ma'am. As it appears that portion is there, my lords.
further apparent on the record that Honorable High Court, by disposing of the writ petition, this writ petition was filed by whom?
The writ petition was filed by the petitioner.
Correct. Was pleased to observe that the liberty was granted to the petitioner to pursue his remedy before the appropriate forum, as the writ petition against such was not maintainable by passing the appellate court forum such and such. It cannot say not maintainable, not entertainable. Anyhow, the word is not appropriate. It is definitely maintainable, but not entertainable. Then it is apparent that did not allege before the court that the selection of the respondent was not communicated to the appellant. Most pertinently, did not challenge the selection letter dated such and such, and did not seek the quashing of this. If he is going by a fact that my bid cannot be rejected on technical ground, then he has a right to be considered. And in that event, if the successful bidder has quoted a lower price or a highest price, whatever, then in that event, the authorities has to take into account. And then he says that appellant himself has admitted in paragraph 9 that his own bid was not acceptable and entertainable, as has not tendered EMD in form of a demand draft, but by account pay check.
In that portion, even in the writ petition, they have said that by petitioner's minor deviation with TW, that is accepted by the petitioner at page number 38. They accept.
Can it make him the or non-aggrieved person or an aggrieved person? You have proceeded that you can't be termed as an aggrieved person. Paragraph 10.
Yes, not as a person.
Then a person may be regarded as an aggrieved person. The right of appeal is also provided. Then you put it on affidavit or put it on facts that the rejection of his bid was supported by all these things. And therefore, on facts, it does not appear that he can maintain. or the order rejecting his bid is infirm or illegal?
The grounds of appeal which are mentioned at page number 34, there are three broad grounds of appeal, which is 19,
True.
34. So,
I see in ABC you have considered,
yes, madam.
but why 10?
10 minutes. They say because nothing will come out of it.
Because the word aggrieved is a very wide connotation. If a slightest affectation is done, can you make him that he is not an aggrieved person? And it does not say that who can be an aggrieved person.
The section talks about any person aggrieved.
So it's of a wider connotation.
Then suppression of material fact for the court.
Page 47, the order of the appellate of the claims of lordship. His lordship saying that the acceptance is bad in law and my rejection is also bad in law.
No,
Page 47,
I
lordship.
failed-
Only 2 paragraphs.
I fail to comprehend this sentence in page 47.
Lordship.
In considering the limited prayer of the appellant,
In consider-
you are the appellant.
Lordship.
Going through the order, document in LCR, guidelines of the rules framed in the regard, and deficiencies so and so, the competent authority has not rightly observed
Lordship.
the formalities as per the rules before going for selection of the
Success
successful
bidder in this section.
bidder in this auction. At the same time, the H1 bidder, now lessee, has also violated the basic principles framed for the auction
Auction
process.
process.
Hmm.
Lordship is questioning the bid of the successful bidder. And Lordship,
As the irregularities have been made
Lordship.
by the lessee
Lordship.
as well as the tahsildar,
Lordship.
there is no scope to consider the prayer of the appellant due to lack of
That
jurisdiction.
has been considered by your lordship because the finding, lordship again remanded to the competent authority. He took a decision and he rejected on the ground of limitation. Then a lordship decided on limitation.
So
Now lordship is there.
finding of fact has come,
Lordship.
but because of
Appellate of the
jurisdiction, he was not competent.
Roman 4 lordship can receive the same page. That is
So now-
Roman 4 page.
Now in this also,
There is a successful bidder and lease is agreement with the successful bidder, my lord.
So the difficulty is then what for the courts are. If you are if the freedom is ingrained in you to do whatever you want to do, and the courts will not interfere, then existence of a court system is a farcical one. There is no, so he's successful. He is raising an issue that this my bid cannot be cancelled because the ground which you have assigned is not in consonance with the law. Then
Was the different fact finding body here after considering the appeal grounds, what
sir, the difficulty he has raised that fact finding authority has committed error in rejecting my bid. This is on technical ground.
now everything is considered afresh by the impugned order, my lord, by the.
But where is the consideration?
Only one.
Where is the consideration? Just tell me.
Page 94, my lord.
Please come from paragraph 6 onward, you read. So it's a non-conclusive finding. Paragraph 6. He says that I am not aware, is not known whether such deposit has been made later on or recovered from the lessee subsequently or not, as the competent authority was a tahsildar. And such information is read. He could have called her. He did not. So this is inconclusive. Then come to 7. Thus that alleging the violation of rules such and such cannot be taken into consideration. More particularly against the appellant, against the respondent, as the appellant has failed to substantiate the lapses so pointed out by his was attributable to the respondent only. I do not know what he means. However, it is observed the appellant has no locus standi to raise. Why? What is the reason?
That too after High Court.
And there was already a direction by the High Court. He has taken note of that judgment. He says that though it has been brought to my notice subsequently, but I am taking into consideration that judgment. And then solely on the ground of locus. Why not? Where is your grievance petition appeal?
Appeal, let's say I have annexed.
Where you have annexed?
In fact, Lordship, last enter compilation I had.
Please, where you have annexed?
But I have not annexed.
This ground ABC, that is the very important one.
Lordship, that has been dealt with by Lordship.
Sir, this is a very important document. We can't remember each and every bit of the facts. At that point of time, you raised it, we decided it. We do not keep in mind that what was A, B, and C.
That is Lordship reflected in the page 45, Lordship, page 45. Enter appeal memo has been reflected in this page 45, Lordship, the detail order. Because
It is a very cumbersome way of doing it, sir. Why don't you do it when he is dealing ground A, B, C in order to show to the court that what is ground A and B and C? Will you not annex that particular appeal, the memorandum of appeal?
voluminous document.
So
Lordship, because Lordship can come.
when you are appearing, volume does not matter.
Lordship, in fact,
Does it matter?
Lordship confusion, Lordship, because
The other volumes are so good for you, then this volume is inconsequential.
Lordship, page 45, Lordship, can you see?
So,
Lordship, the Tahsildar, peruse the petition and LCR received from Tahsildar, Tahsil Office, Birmadripur. The documentary verification is found that the following formalities have been maintained in the Sairat case.
My lord is asking that.
I know.
What is your ground before the authority? That we want to see whether that is in consonance with these findings or not.
Lordship,
That is what we want to see.
Lordship, that I have not annexed because we last occasion because I had produced the entire certificate copy. And
Again.
Lordship is very voluminous, Lordship, more than three.
so what?
Lordship,
There are a provisions which says that I crave leave to refer the memorandum of appeal at the time of hearing of the instant writ petition. That is not known to you. It is being done very frequently. You should crave leave of the court.
that's true, Lordship. I'm sorry.
So,
But that's because it's fourth round litigation and this
So-
official Lordship deliberately. Lordship here.
so should we direct this system that whenever it is a third rounder or second round, all the the pleadings of the earlier writ petition should be annexed,
No, I'm extremely sorry,
or
Lordship.
should be attached?
Lordship, kindly come to page 87. I got a Lordship one paragraph line finding. The officer has a head, Lordship. Hold it. In the subsequent, also huge amount of revenue has been collected from the said lessee. For that reason, he is not entertained, Lordship. Because Lordship under what?
But that has gone.
No, Lordship.
Those orders have gone.
This order has gone. Lordship.
So this order has gone.
I have not.
Now I
am
just
not
wanted,
saying-
because he is dealing A, B, C grounds. So at least either in the pleading you should have said that what is ground A, what is ground B, what is ground C.
But Lordship, finally, he decided on the ground of agreed party.
Sir, I do not know if you have raised something else, then I do not know.
No, Lordship, it's the same appeal which is pending from the day one, not a test. And Lordship, ultimately, while dealing with Lordship, those grounds, he has-
Maybe my grooming is very bad.
So, Lordship, because I want to Lordship to convince the Lordship.
No, how can you? Because my mind is blocked. Unless I see that grounds, it will not be opened. Because he's dealing each of the grounds, then I must know what are those grounds. While dealing with a particular factual ground, he has not recorded anything. So is it a proper way of deciding? We have to ascertain.
That's
We are not concerned with the decision, but the process in which the decision has been arrived. So we can say that he has not followed the mandate of the earlier order where the court has directed him to decide on merit.
merit. But
He has gone only on a locus.
in addition to that, Lordship, only I can submit, Lordship, the same appellate authority, Lordship, have decided on merits. That is done Annexure 1. But can he lordship, now lordship is come up with the ground of lordship, annexer 1, the same appellate authority. He's saying, he's questioning the entire bid system and his lordship answering about my disqualification. But here
We have to see the grounds. We are stuck up. At least I am stubborn unless I see ground A, B, and C. I'm stubborn.
I said tomorrow I will produce entire.
Whatever, that's coming
Tomorrow lordship.
next
Next week I have.
next Monday.
No, next Monday I'm not available.
Make yourself available.
Next week I'm not.
Oh,
So lordship, reopening lordship.
reopening.
Yes, ma'am.
Lordship,
5th January.
keep them. Only a trade lordship. In the meantime.
No, come, no.
Item number 7.
Item 7, Your Lordship, I was granted a lease for 3 years by virtue of the collector's order, signed very matter, Your Lordships. But for 1 year and 1 month,
Show us the provision for extension or exemption.
Your Lordship, they are covered by a judgment of this court.
I'm taking a dissenting view.
Your Lordship, Your Lordships, may I?
Rather, my brother, if I join, at least I can take a dissenting view.
Your Lordships, we are slightly differently placed, Your Lordships. For
My view is that we cannot issue a mandamus
may,
upon the authority to act beholds the law.
Your Lordships, the tender was called for 5 years, but because of litigation, we were only confined to 3 years. Though I deposited everything for 5 years, thereafter they did not execute it for 1 year and 1 month. The agreement was not executed because cases were pending in NGT for the entire district of Balesur. Even when it was executed, then for another 1 year, 2 months, we were not allowed to operate because of the continuation of the matter. So we got just few months to operate, Your Lordships. In the similar circumstances, this court has stated, Your Lordships, only because if the matter is pending NGT, because the EC is a must before a person starts. And as the EC has to be given the name, the Tahsildar. So that is the reason, Your Lordship. May just look at this.
Who is for the state?
They said that because of the act of the court, the part should not be.
That's a legal maxim, acta scuri,
Yes.
neninam grababit.
Yes.
That is a different maxim, but this is not the case of such things.
Yes.
No, this is misplaced. This is misplaced. This maxim has been misplaced or misread. This is something different.
We very bona fidely participated. The EC actually, Your Lordships,
Go to them.
Your Lordships,
Go to them.
Your Lordships, in fact, we made a representation also. We are back
Then
in August.
you
We are back in
consider
August,
it.
Your Lordships. We are back in August. After the
You
execution
consider
also.
it.
And they have taken the entire 5 years
Whatever.
security deposit.
Take it.
If my lords direct, we will consider, but if the lordship make.
I'm telling you, then there will be another question. If you have not permitted him to operate, yet you have taken the entire period, then in that even refund the excess amount.
My lord may pose a subject. to
Refund.
lords Kind consider. My lord may pose a question to my lord.
You pose a question. Why you are?
I pose a question
Yes, through us.
through this honorable court, my lord.
Yes.
Whether she was a successful lessee, whether a lease deed was executed with her.
She says that yes.
No. Well, let me.
Oh, this is very interesting.
My lord, that is what I am saying.
She says that it was executed but could not be
No,
made, but she could not operate the Saira 1.5 years because of certain court cases, only operated for a few periods.
But what are those court cases is also important. My lord,
First thing is you are putting a very basic question whether any lease agreement or lease deed was executed.
that was executed subsequently pursuant to the concession made by the petitioner before the court of the Tahsildar, a collector. But initially she was the successful bidder. She didn't deposit the security amount. Then it was given, the second successful bidder was given the opportunity. Lease was executed with the second successful bidder. Then subsequently the second successful bidder left. My learned friend approached this court.
So-
Then in appeal,
I think he has jumbled up with another case.
I think so, Your Lordship.
Oh.
Annexure
He
11.
she says that you have jumbled up with the facts with another case. This is not a case.
Annexure 7, your lordship may kindly see.
See, Your Lordship.
Annexure 7, your lordship may
That's
kindly
why
see.
my
What
beginning
is the order?
statement was very clear that the auction was called for 5 years, but we were only allowed, we were given by the orders of the collector for an execution of a lease for 3 years, and we are confining our prayer for 3 years. Having that order being in place, you did not execute the agreement for 1 year because your hands were stayed by the NGT. Even after executing the lease deed, you did not allow me to operate for another 1 year and 3 months because of the NGT order. That's all there on record of an additional affidavit. All those orders of NGT, entire state of Baleswar was
File a
under
reply,
scrutiny.
Then
These facts are wrong.
Para 5 and 6 of this.
These facts are wrong. Just tell us. What she says is factually, is it a wrong fact or incorrect fact?
alert subsequent execution of lease for a period
Sir,
of
that is
3
the
years.
another aspect. Sir, it is your action. You are representing the authority. If you have executed the lease agreement or a lease deed, whatever, can you deny that you never executed it?
You have executed.
Correct.
Sir.
Once you have executed, then you have accepted him as a lessee. Means you have given them a right to extract the mineral, minor mineral or mineral. Now their grievance is they could not operate because of the intervening order of the NGT for a pretty long time. Can you deny that there was any hindrance? There was no hindrance, there was no obstacle, there was nothing
That is why,
that prevents him from operating.
that is why I take your lordships to Annexure 7.
You took a different story that he is not even a lessee, no execution, lease deed is executed. I was shocked with that. That why you say so. And if it appears that the lease was executed by a authority, then
Authority subsequently went.
whatever she was talking about a subsequent thing, she has come, I am not going for a 5 years. Tahsildar has ordered to execute the lease for 3 years. Even the lease is executed for 3 years. 1.5 years or so, she was prevented from operating because of the intervening NGT order. So she has come that I could operate only for few period. I have made a representation so that you can extend the lease or you can permit her or him to operate for that particular period, if I correctly understood.
Regarding that NGT, I'll have to take instruction because NGT is not going. I'll have to take instructions from the authorities regarding.
Take that plea. I was shocked with that.
So far as
That there is no lease agreement and she's saying there is a lease agreement. So, very, very interesting defense. God.
Why I said there was no lease agreement because initially.
Past incident is inconsequential the moment you executed a lease agreement to him. Inconsequential, whether he was L1, did not deposit, L2, fails, whatever is immaterial now because of the issue being a very limited. That she could not operate the Sairat for 3 years, despite a lease for 3 years is executed in his favor.
Regarding that NGT, what my learned friend is placing, and I'll take it.
Where is the order of the NGT?
That's there as annexure 14 of page 17 had additional affidavit.
Page? Page?
Your Lordship, that may not have come on record, but that's we've given a copy to the state.
Which one?
Your Lordship, additional.
No, you have put in some additional affidavit.
That hasn't come.
It has not
Now
come.
they are supplying the copy.
This is there. The NGT thing is recorded
Not on record.
by the government.
Which page?
17.
Why you did not file it and give him a copy earlier?
I leave. Apologetic. The paragraph says that the query was not allowed to operate due to NGT case.
So you were allowed to lift it,
Not the entire period, Your Lordship.
or whatever.
Not few months only, Your Lordship.
So whatever.
That no, the entire lease period we are not allowed to operate.
The quantum is same.
Quantum remains same, but then Your Lordship, practically how can I?
So we'll direct the refund for the rest of the amount.
Since we have not been allowed to operate.
No, no. We will say that since you were not permitted to operate, refund the amount of whatever the charges which they have collected.
Something else, Your Lordship.
No, I'm taking a different view. That was in case of COVID-19. Force majeure clause was
Your Lordship. Same NGT case.
it was a force majeure clause which was applied. No, and this is a case of post-COVID.
Your Lordship, it says NGT. No,
It is a post-COVID period.
No, Your Lordship, look at it's NGT.
Post-COVID period.
Your Lordship will see 4 and 5. Same. Your Lordship,
I am looking at paragraph 8.
paragraph 8 is because of the orders used to be given.
Whatever.
It's not a
The
certificate.
consideration is that during that period there was no operation of the Saira. So naturally that force majeure clause was applied.
Because of a judicial order by NGT.
Yeah? No.
Lordships.
Why you accepted the lease of 3 years?
Your Lordship, we did not know about it.
You
We
did
did not know. Nothing was because Your Lordship, what happened?
Is the ignorance a valid plea in before the?
Your EC is issued in the name of the Tahsildar.
Obviously, it has to be.
Yes, Your Lordships. Now what has
Has to be.
happened? Now, Your Lordships, what has happened is
Nothing.
Your Lordship will look at that order. Your
Just go through it and just tell us that what is this and what, because this copy has been served on it. It appears that an additional affidavit is filed by the petitioner in the instant case.
Eight.
Caveat is already lost. Why you will not serve the copy?
First time it has come, man. It has come for the first time, man. Government has served, man.
I think Sunday did you attend?
He is the private party, man.
Sunday did you attend the symposium your bar association organized? Did you? Or did you not? You have not heard me what I say. So the purpose of caveat is that the advance copy or at least the notice has to be given or copy has to be given to him. It is not dependent upon whether the matter is coming for the first time. I was critical against them in my deliberation, but appears to have missed your submissions. This could also be there. Because this is the first time I come to know that the caveat is absolutely immaterial. Let him file. When the matter would be listed, first time listing, so then I will serve the copy. Before that, I will not give.
Received any minor caveat.
Sir, there is a noting when the matter is listed, will you not? It is written caveat petition number 1331 of 25. So, despite the caveat having lost the comma, the Anyhow, sir.
This is a matter relating to a tender of tugboats, my lords.
Tender of?
Tugboats in the Paradip port.
Tugboats.
And my lords, similar matter, my lords, we belong to a consortium. So we are the lead partner of the consortium. The similar matter was heard by your lordship, my lords. One of the members of the consortium had also filed a writ application. That is WPC number 33659 of 25, Ripley Shipping Private Limited, my lords.
Okay.
And my lords, a counter has been filed by the Paradip Port Trust just last week. We have sent it to our clients for instructions. I pray that the matter may come up along with this WPC number 33659 of 2020.
We're just giving that order. This is really new tug. It's an environment friendly operation where these green engines will come to operate in the marine, in the ocean. Now, this order, if your lordship sees, they submitted before this court that they had qualified in the technical bit. Para 2 manners that is recorded. It's the same.
Yes.
Para 2, it is recorded, they have qualified. Now, this manner, with great respect, is an incorrect state. They have not qualified. At the technical bid stage, all bidders have been thrown out. All bidders were not considered because they had submitted documents after the cutoff date, and we had come up with a proposal for fresh tender. So now, because of this observation of your lordships, that we will stay our hands off the tender, so we are not able to proceed. Now it's for marine life, and it's all
We are not going to tag it.
My lord,
My lords, may I humbly
I
submit, my lords, I am
understood that
appearing
why
for respondent number
he
7.
my lord.
so innocuously prayed for tagging.
No, lords, basically.
No, sir. Let us.
That-
You were directed to file.
We have filed. My lords, within time, we have filed all our affidavits, and we are, in terms of the order, my lords, we are staying our hands off that.
When that matter is supposed to.
That is coming up on Thursday. Last Thursday it was there.
Let this matter be listed on
Thursday.
Monday. So that matter is coming.
On Thursday, my lord, I am appearing for respondent number 7. My lord, I am the writ petition in the other matter.
But hearing has to be done, na? Hearing to we are taking up.
Health issue.
Oh, what
Lord,
has, sorry. What has happened? Can you call a doctor?
Yes.
The OP number 4, making allegation against me, has selected the OP number 5 and I have made the grievance before the commissioner of exchange. That is still pending to inquiry into the allegation.
What? This is a serious allegation.
My lords may see.
Why have chosen 5 and 6?
Yes, my lords. My lords may kindly have page 36. Page 36. My lord, previously, the petitioner was not the person who had been selected to supply vehicles. Now, my lord, that agreement was terminated with effect from the date it ended. My lord, will see at page 36. It was for a period from 1/12/2024 to 30/11/2020. Now, in the second paragraph, those derelictions that my lord were found, and then thereafter, my lord, so his agreement was terminated with effect from 30/11/2025. That now, my lords may have kindly have my lords page 43. After the termination, my lord, a tender was floated for the same work. Another new tender was floated at page 43. This was on my lord 3rd of November. So, my lord, challenging his termination and this new tender, the petitioner approached this honorable court. My lords, please. My lords may kindly have the order on the basis of the grounds taken therein. My lords are pleased to dismiss the writ petition. Thereafter, my lord, this happened, my lord, on 14th of November. Now, in the new tender, the last date for submission of bids was 17th. So, after being unsuccessful in this writ petition, he went and filed his bids. They have never submitted his bid. My lord, because we have let a copy.
Similar, what he could not achieve directly now we can put in his bid. And it turned out to be L1. The reason because why we have not selected.
Just 1 minute. No, that was on a different ground. He wanted to challenge that third November.
Yes, Milord, but Milord,
So-
termination was.
No, termination was that it is operative till 22nd of November.
Yes, Milord.
So he was there
Madam.
operating. You have permitted him to operate.
Yes. Till 30th of November.
Correct.
Madam.
And then 17th was a date for submission. He submitted.
So he went back and he submitted his bid.
Correct.
Now,
You
in-
permitted him.
The reason, Milord, why we did not select him is.
Where is the reason?
Page 36. At page 36, Milord.
Yes.
The reason was, Milord, we terminated him due to dereliction of duty, Milord. Now, Milord, on the basis of-
Sir, there is a recording till July. There was a satisfactory performance at his part.
Yes, Milord.
Then completed to terminate.
After that, Milord, we see the second paragraph, Milord. The second and third paragraphs, Milord.
Yes.
In the termination order itself, Milord, the second and third paragraph.
Yes, please.
During the month of June, you have not responded to the instructions of the Superintendent of Excise, where order dated so and so. After lapse of 1 month at your sweet will on so and so, your above 2 hired vehicles and driver reported before the concerned officers. Inspector of so and so have reported by so and so.
What?
Milord, because of these allegations, because these services were found to be unsatisfactory and there was dereliction of duty, Milord, we terminated.
But that was not reflected there. Why you extended the period of contract?
No, Milord, we have not
Till
extended.
20 Yes, you terminated in the October and you extended till 22nd of November.
Milord,
The date of
the
completion of
agreement
the
was
contract.
till November.
So why you extended?
So, Milord, we said with effect from the date. on-
Sorry, we can't appreciate this.
No, Milord, we allowed him to continue till the period is agreed.
Why?
Yeah.
Why?
But that.
If the entire performance was unsatisfactory, why you extended or allowed him?
The agreement
Sorry,
provided.
our judicial recording is there.
Yes, Milord.
We say the satisfactory.
Yes, Milord. So, Milord, it's a fact. I have to admit.
There was no dispute until the month of July in performing the satisfactory duties and responsibility.
Milord. Milord.
So up to July, we have recorded and the judicial recognition is sacrosanct.
Yes, Milord. And Milord, we have also allowed him to continue till November. That is also admitted. But however, Milord, this tender that we floated on the 3rd of November,
Yes.
my lords will see this tender was to take with effect from 1/12/2025. So after the date, after the agreement period was over, from the 1st of December,
I was allowed to participate in the tender.
now you can participate. How can you prevent it from participating? If somebody wants to participate,
The allegations are totally false, Milord. That is why
that is
I
a different
made
aspect.
the
Not on that.
No,
But my lord, in page 43, which is the
we don't find any kind of the justification in this regard.
Because,
No, this can't be.
Milord,
And-
chose it. Milord, wise not to. Milord,
And then he is a Maheshwar Bera.
Milord. So now,
I
Milord,
searched to page 47, you know.
And whom he has given?
That third person, that
No.
28,360.
OP 5 and OP 8, Milord, KS Travel.
28,360 and
And Lakshmindra Sahu and KS Travel. These two.
28,999.
Yes, Milord.
So
The next five.
he was very, very competitive.
Yes, Milord. That Milord, knowingly he has put in a price, Milord, which bound us to, Milord, because but we have already, Milord, taken note of the fact that he was not, Milord, up to the marks of his previous services were concerned. So, my lord,
There was one incident of July, and then you said then we were given to understand that the contract is expiring on 31st or 30th of November,
my lord,
and he was allowed to continue till 30th of November.
admittedly, my lord.
So
And my lord, the tender was floated, my lord, may see a state.
on 3rd, 17th, he put it.
Yes, my lord, he went back and my lord.
So where is the difficulty?
I cannot deny.
So-
The only reason is because in some aspects we chose not to select it.
Then don't invite a tender. Don't invite. Choose somebody else.
Now, my lord, one recent development, I bow down, my lord, because that I cannot deny.
No.
One recent development, my lord, the agreements have already been executed with Open.
Maybe,
That
sorry.
I've given. That I've given, my lord's name.
Sorry. Implead him as a party.
I have
Given. Impleaded.
5.8.
Notice. A short notice before vacation can be. It is all.
My lord, we are challenging the rejection of the technical bid. My lord, during the pendency of the writ application, they communicated the reasons on 3rd, 28th of 11th. So we filed an amendment application on 3rd of December. And copy sought on the carrier.
Without recording my concession.
And second part, my lord,
Why you are apprehensive?
The instruction comes.
This is something a
I don't
and that was communicated, my lord, and today they are filing the objection at 11:30, they are supplying the copy. Well, not they. And we are ready with the consultant. The only thing is adding the ground and the prayer is only.
So far as the IA for amendment, I have no objection, let it be allowed. We have a preliminary objection regarding the maintainability of the writ in this form. One is the L1 bidder has already been declared. In view of AFCON and subsequent judgment, they have to include him as a party.
They will include him as a party.
They have not in their counter.
They have not disclosed that it's still back in the counter. Today they filed, they have not disclosed that.
No, that's there.
Please, L1 and L1.
Since November.
Devar, will you not disclose that you have already issued?
It's very much always, it's there.
No question.
When you file a pleading, then you should also disclose it.
We have disclosed.
And take a plea that it is incompetent. Now you are taking a plea of demur.
We have also taken it in the counter.
No,
Disclose.
No.
I have not seen the counter.
No, it's mentioned.
Where? Show us the para.
No name and details of the person should be amended or no.
No, paragraph 4. Man.
Oh, that is. There is no details, only the name is there. Para 4. And that we are getting the information at 11:30 today.
These are all listed exchanges. It's a 5,000 crore tender.
My lord,
everybody knows that
it's a long-term contract. 35 years for operation of a mining and development mining and operation.
Yeah. Petition.
Go for 5.
Very bad judge.
Monday.
Yes, Monday.
Very fair, my lord. I think the law is now settled that the bidder has to be implicated. So
Sorry, Lakho.
Number 12.
Please, Your Lordship.
Yes.
But it's a matter where Lordship, but I will the assistant Lordship will select. But the Lordship had asked about us identical order. But where I'll tell you Lordship very briefly the facts of the case. But our notice inviting tender was issued for transportation of coal from to Kamakanagar route. Now, in that tender, there was a stipulation, a condition, clause 3(1)(f), which said that a site inspection certificate was required. Now, the tender, after
I think there was one matter which I read.
that is what I was pointing it out to your Lordship.
One matter was earlier before, my lord, and that is WPC number 32917. My lord was pleased to issue notice and interim stay was granted.
This is a different matter.
And
No, this was a matter, the site inspection or something, if I correctly remember,
We
had an officer to deal with.
Inspection, we deputed a representative and several reminders were given that site inspection was done. We have next photographs to that effect also. But despite that, without assigning any reasons, the certificate was not issued to us. At that juncture, we approached this honorable court where your Lordship was pleased to stay the tendering process for a limited period.
So you are already protected. The entire process is kept at halt. So only thing is that
yes, today I am appearing.
Additionally, I have
Not my directly for the copy. I will come back because that matter is 217. But
I have twofold submissions before your Lordship. Firstly, this is really for admission at this admission stage. The second thing is that if your Lordship kindly permits me, and if your Lordship kindly to tag it along with the
that we will consider. That will consider. Don't worry. That will consider. It will appear one after another. There is no difference.
And the third, which is the most important aspect, if your Lordship kindly considers the prayers made.
in that case, in already we have issued the site
The
site inspection certificate, which was in the subject matter of that case, that was issued on the
Site
date.
inspection has not been issued till date. That is my instruction.
That is
If your Lordship kindly
Yes,
kindly sees the press E, F, and G. Kindly sees press E, F, and G, page 24. Why I'm saying this, my lord, is that your lordship, if your lordship kindly consider.
No,
lordship,
will consider, not at the admission
But I'll tell you,
stage.
lordship, why?
No, sir.
Just record my appearance
E, F, and G.
Sorry,
appearance
we'll consider these, you are trying to reopen the many things. We'll consider it, let them come with the affidavits, otherwise we will not do it.
I'll file affidavits.
Will not do
It
it.
may be recorded that they have already provided site inspection.
I have filed the affidavit, not affidavit.
Where?
We should cite
This is appearing for the first time.
No, I have filed
In this writ petition.
corrected writ petition.
No, not correct. Fine.
No, he says that I have been persistently requesting you to give me a site inspection certificate, you are not issuing it.
One. In that.
Have you issued a site inspection?
Connected matter, that is according to Hindol.
No, this is, he is talking about SA, is SK Contest and Minerals Private
I'll
Limited.
take instruction and file affidavit. You also may record the
Whatever.
appearance today. So direct.
Copy has been served.
No, they have not filed.
Copy.
Yes, but I'll immediately serve it in the course of the day.
The challenge is, sorry, the main, the principal.
Blood 1, 2, 3.
Who is three?
3 the person in charge, who is general manager.
Can you, is placed in a individual name, not in the capacity.
But 2 and 3, because it should have been 2.
Sir,
Two.
why you have made him individually a party?
Because he's going to be general manager.
He may be, then you could have said the general manager of this area. Why you have named the person?
Because they have made me 2 and the same person.
By name, they have made me third, the restaurant three. They should delete the three and one, two, I.
No, you can represent the general manager.
Because I'll tell you, Lordship, I believe that the entire correspondence, if your Lordship kindly recollects the correspondence by which they tried to give certain conditions which were not even part of the tender.
So why you will name a person? He was doing it in a capacity of.
Doing it in a capacity.
So
doing it in a capacity.
Why individual name is given?
If you kindly gives me leave,
If he is transferred or retires, then what will happen?
That's true. If your Lordship kindly gives me leave, I'll immediately strike out then. And it will continue as the general manager.
You want to As yet we have not.
Direct my name to be the cost.
That will automatically.
The William Shakespeare said that what is there in the name, in the Hamlet, which he wrote.
So on that day, you will be appearing for that case. And this case is coming. So in our order, your name is reflected. Taking on record your Vakalatama appearance.
Serve him a copy today.
I'll immediately.
Item 13.
Yes.
Obliged.
Item number 13.
Need please. This matter what is happening. Crux of the issue is this. I am a contractor.
Where is the letter dated at 25/11?
Yes, it's at page 321. 321. But if I may indicate, it's a
Yes, we'll see to it. Don't. Thanks and regards.
Plus that this is the email.
PFA show cause notice.
Yeah.
Oh, that show cause notice.
Yes, that is at
Where is the?
That's the next page.
Okay.
322. That's what is happening.
Just one.
Yes.
Yes. Yes.
Yes. What has happened?
Then what happened?
After that,
Did you file your reply?
no, I have challenged it at the show cause notice stage.
Is issued by the general manager in engineering,
Yes,
NBCC India Limited.
balance.
So-
And what has happened, in this case, they issue this show cause notice to me after I point them, sir, 5 crores rupees worth of money, admitted debt. You are holding on to it, you are not releasing. I write to them that on one hand, you are holding on to my money and crippling my working capital. On the other hand, you are telling me to do this work. So I write this letter to NBCC. After that, this show cause notice is issued to me without addressing any of my concerns that I raised. Will also 19/11/2025, your lordship will see page 315. I raise detailed grievances at page 315.
Show me a judgment that the court will go into this aspect at this stage of show cause.
I only.
I just want to show me. Show me. You are talking. Can it go to the extent of malafide? Can you go to the extent of show us?
Only
show cause stage.
Yes.
You know the limitations.
But they just make this case. Let me just cite this judgment.
It's a show cause notice for blacklisting that was under the consideration in this judgment. However, it was a show cause notice. Well, my case that I'm pointing out before your lordships is that the show cause notice is issued on a premeditated basis.
No.
And therefore, Millets, I'm before your lordships. I'll also demonstrate, Millets, from my petition, Millets, that how your lordship, may I just show a few pages to your lordship, and how I am Millets pointing out the arbitrariness and what they do.
Understand. You said from the moment you raise the payment of the dues, this, according to you, this is the outcome of that grievance. Understand? Go and raise.
Let's
Go and raise.
that Millets, I bow down to your lordships. Millets, they let that Millets, I am not on that aspect for a moment, even if I am not on that aspect. Because what they have done in another tender, there are another one was 24 3 BHK quarters, which is the subject matter of the show cause notice. There was another 42 2 BHK quarters at Malkangiri, same place. In that 42 2 BHK quarters work, Millets, they took a portion of my work. They took away a portion of my work for giving it to somebody else. No problem with that. What they have done, the rate that I had quoted, Millets will see this. The rate that I had quoted, that is 6 crores 7 lakhs for that particular amount which they have quoted. The same rate has now become the base inviting tender. And here is a case where Millets, I had where it is the L1 bidder who should get, not the H1 bidder, because at low price, the state's endeavor of the NBCC being a PSU, its endeavor should be to attract the lowest rate. What they do, they took the work from me and they have floated a tender at the matching the exact same rate at which I had given the tender. I had received the tender. Plus, that increases, and your lordship will also visualize one more thing.
You know the judgments on that keeping a reserve price is also within the domain of tendering authorities. Can you say that you cannot do it?
All I'm saying, Millets, all I'm hinting, Millets, today before your lordships is at the inherent arbitrariness. It is on the face of it. It's manifest arbitrariness.
This, what you say is the manifest arbitrariness cannot be utilized in this fashion. It has to be, because your allegation is, you can't say that this notice issued by the authority is bad, that the authority is not competent to issue a show cause notice. Secondly, you can't say this particular notice is not in tune with the conditions which is incorporated there. All these things, we cannot go into this. You are saying the intention which is hidden. In that event, you go and file your objection. File your objection, we will extend the time in their presence to file a reply to a show cause. Keeping all the point open, we are saying that all points which is taken, and they will deal with each point.
And let that Millet's objection be considered by way of a speaking order. That's
always
that may be indicated.
This is the fundamental principles.
Right. Very true.
Yes.
I may be permitted, my lord, to submit on behalf of OP Council, Mr. S.K. Das. He is on accommodation till 19th.
He is on accommodation? Which accommodation?
He has gone for a health checkup to Bangalore.
We are disposing of the matter. Are you not there in a matter?
Yeah, I may be permitted to submit on his behalf. He is not there. So,
are you engaged in the matter?
Yes, sir.
So,
they are caveat.
So what?
Only caveat has been filed.
So,
copy may be served to us. So, my lord,
I have served it, Millets. I have served. I have the proof also. Day before yesterday, we went to their residence to serve it. The door was closed on my clerk's face. So we served it by email.
Huh?
Yes, that's
Door was closed at his face.
at my clerk's face because no one was there.
Oh, that is the door was closed.
No, Milord.
I said it was closed means somebody opened it and it closed at his face. When you use this expression, what you should know means.
Milord, I mean what I say, Milord. When the copy was, my clerk went to serve it, Milord, nobody was there in the office, but it's an office come residence. It was given to whoever was there. It was given to her, and she inquired over phone, and it was told over phone not to receive, and the door was closed on his face. So therefore, I went back and served it by email. I have served it. Now,
To
if he
whom? The
wants,
party or the council?
Council.
or the council.
Copy may be served to us now.
I am giving one more copy. This is the copy that I went to CDF to serve it. I'll serve it now again.
It may dispose of in the next day, we will file a counter.
Very good. As your lordship, please.
He wished that.
We are passing an interim order. Staying the entire proceeding. You cannot proceed on the basis of the show cause. You're passing. Prima facie arbitrary.
No, you are not the council.
Yes, madam.
Are you empaneled by NBCC?
No, I'm on his behalf. I may be permitted it. Mr. Das is empaneled. I may be permitted.
So you have been served with this petition today. Now,
I received on behalf of Mr. Das.
then what do you want to serve on us?
No, I have the copy of agreement, copy of show cause.
So on that
So it
basis,
is also agreement, show cause, everything is annexed in the petition. What? What? Tell me.
No,
Then what?
my lord, understand that NBCC is a contractor. We have given them subcontractor work.
Yeah.
And the amount of tender is 27.93 crores. So they could not, they signed the agreement to finish up within 11.
Their allegation is that I have executed it. There is a due to the tune of 5 crores. When I approached you that please pay off because you can't stall those monies because it is a running capital. We have to do and execute. When you get the money, you becomes very annoyed and then you issued a so-called notice. Though he say closed at the face, now slapped at the face by this so-called notice.
The agreement, and the agreement was to complete it in 11 months. Now 3 years, 8 months has gone. And the so-called was issued much after.
Much after. Then why you permitted him to continue with the work?
And if he could have completed the work, the progress was very slow.
So can you deny why you, that does not mean that you have extended the period. If you permitted the contractor, subcontractor to continue working, does it not imply that you have extended the period for execution?
So many reminder, my lord, has been given in form of letters.
Yes.
At the last, so this so-called has been given.
So whatever can you withhold the amount for a work which he has already done?
No, I have no instruction about withholding the amount.
That is what he says, that there is the outcome of that.
We'll give the counter reply and we'll
What give a counter reply? What you will give? Then we'll have to stay.
But stay is not required, my lord.
Why not? If you proceed and pass an order on the basis of show cause, where he will stand? Tell me. Where he will stand?
Lordship direct us, we will obey. But now,
What directors?
since the conducting council is not there, it may be taken up next.
you have filed caveat and we would not receive the copy. And
Mr. Das is not there, nobody in his family is there. So the relative,
somebody is there in their house, in his office, residential office, nobody.
A show cause notice dated
Then he is lying.
25/11/2020.
Yeah, we will file a counter.
Oh. Before the authority filed a counter. Yes.
Item number 14.
For the authority.
Who has issued a show cause notice? Okay, let's go.
Thank you, Your Honor. And here the petitioner was awarded with a contract for construction of bridge. Your Honor. By the authority, it was said that drawing and design was time to time they have changed and they have extended the work. And ultimately, on the ground of low process, they rescinded the contract. That rescindation of contract with show cause notice, it was not, so show cause reply was filed. It was not considered, so I filed a petition, that is pending.
Why you did not file the reply?
We have filed, but.
So where is the ultimate decision?
At Annexure 6.
Page?
Page 26. 26.
26.
The proposal has been rescinded. There is this order is not a challenge, Lord. And another writ petition, Lord, that is pending, and it is fixed to Lordship day after tomorrow.
What was the reason for submission of the?
Lord, that is in subject matter of another writ petition. Here, Lord, different is that in the next letter, Annexure 7, they directed for measurement of your work.
Definitely, because
Lord,
that is in order to ascertain the liquidated damages.
Yes. Lord, that.
So that is.
Lord, that I prayed for time because some health issues there, and they made it ex parte without any notice, Lord.
Okay.
And now they are saying that you accept that.
You give them an opportunity. There may be a very competing circumstances. What prompted you not to appear on that day?
There is some health issues there.
Where is
application? I filed application. They
Where
have
is
extended. I filed applications and they have extended. But
Huh?
while measurement, they have not called for me, and they made it ex parte. That is the Lordship kind of glance at page 29 and Annexure 9.
They extended what?
For measurement. In my presence, they made measurement that was extended. And on the 30th.
So you cannot take for a ride every time. Twice they extended, and you continue taking a dilatory tactics. Then what to do?
Because on the day fixed, I appeared. On that day, the officer was not present. That also I have given.
Then?
But it has went down ex parte. Lots of kind of glance. Page 29.
You appeared, the officer was not there. Then who did the measurement?
No, that is a different date. The date when
after that or prior to that?
No, the date on which the measurement was done, I was absent. I was not called for.
You said that you were present. Which date? Previous date?
That is different date.
Previous date or
previous date. Previous.
Yes. You were present.
It has been, they have stayed. That expecting we have done. And
only thing is that you were present when they fixed for measurement, but the officer did not come.
Yes.
So automatically
is not done.
Correct. So automatically the next date.
Done, it is in this.
Next date was fixed.
Yes. That was not.
Which was communicated to you.
No, that is not intimated, and they have done it.
Then how you become ill? How do you know that I asked for
subsequent date? Subsequent. When I become fit, I approached.
It goes miles above my head. Factually.
And I am applying for that you supply the copy of the measurement. That also they are not giving. And now they are saying that accept Annexure 13. And I am objecting to that their measurement. And they are not supplying. Also.
The instructions your lordship has to.
What? If I correctly understood, which I understood in 5 seconds, that you have rescinded the contract,
yes.
Final measurement in order to ascertain the liquidated damages which you have suffered. The dates were fixed for the measurement in their presence. One day your officer did not turn up. The second day now the dispute or the confusion is still there in my mind, which is not cleared by him.
There are 2 dates
whether that next date was communicated to him or not? It's a confused state. If he's communicated, did he prayed for an accommodation on the ground of health? Is also confused. This clarity on two aspect I want. So can you give a clarity to me? He is confusing.
No, Lord, I feel mercy, brother. I will.
Sir, I simply want.
Not a,
There are two. You
Yes.
can't mingle everything.
no, Lord, I'm not.
First, you tell me.
Lord, 25.
You were present on earlier occasion. I understood.
Yes.
On a particular date when they took the measurement,
Yes.
there are two aspects. One is whether that date was communicated to you.
Before measurement, when the date measured, they have not given.
Take us to your date chart.
Lordship.
Your date chart.
Yes, Lordship.
Any? Not.
Yes,
Take it to your date chart, sir.
Lordship. 30th,
18th November.
18/11, 2024. Petitioner
Petitioner was
was
asked.
number 2 to remain present at the work site on 25/11 for final measurement of the work.
Yes.
Then 25/11, petitioner requested OP number 4 for deferment of measurement on health ground. Lord, then 30th 12, the petitioner was intimated that measurement was taken ex parte. That is, they have done it.
Sir,
At that time, they have
sir,
done it ex parte.
the moment you said that the officer was not in the office, where is that?
That is Lord, another date is for acceptance. I have taken. Acceptance I have taken. One date. Sorry, I'm Lord. 25/11 is one date. I have prayed for health ground. And the date which they have said that you accept, there I have taken one time.
So,
I think, Lord, I have.
so it
clear
was once
Actually,
you know,
still confusion is there.
once you know the 25th
Yes,
November.
I have not read the brief. That's why I am asking.
Section 9, Your Lordship, page 29.
Yes.
There are two dates there, Your Lordship. Reference the letter with reference to the subject cited above and the letter under reference. It is to intimate that you were intimated once and again for attend the above said work site on 25/11/2024 at 11 a.m. in which you was absent, Your Lordship. And again on 10/12/2024 at 11 a.m. for taking final measurement due to recession of the contract. There also he was absent. So in the end, he has been told that so the department has bounded to record ex parte measurement and to prepare the estimate of balance work for inviting the tender work for the same work which will be binded upon you. The last three lines, Your Lordship.
These dates were communicated to him.
Yes,
He
Your Lordship.
he paid for an adjournment on 25/11 on the health ground.
On which
For
they have measured
on
also not there.
10/12, whether you intimated him the date
Yes, Your Lordship. You were intimated once and again, Your Lordship.
once and again for that's a
Once
wrong
again,
English.
12,
Forward is a wrong English. It should be to attend the above.
I gathered is that on both occasions he was intimated.
No, show us the document that he was intimated.
But that part also they are not saying on which date they have measured also.
So they were saying that if he was not intimated on the second time, he may be called again and a final measurement may be taken in his presence.
That if they measured in my presence, that no. Then we do. They are not supplying. I have also called for the copy of the measurement.
They are not supplying. That also I have avoided in my petition.
Well,
Speaker.
where is the letter communicating this final measurement?
No.
Yes?
Asked to come and accept, has been asked to come and attend the office on 7 January 2025, Your Lordship, for accepting the final measurement for further course of action at this end.
When the final measurement was done?
That is not.
That I think on 10/12, Your Lordship.
Where do I get it?
As I'm trying to interpret Annexure 9, Your Lordship.
No, I have read it. Don't try to interpret Annexure 9. Not so easy.
Your Lordship will dispose of this matter stating that if the final measurement was not taken in his presence and if he has not been intimated, they may call him for
Eliminate they will say, let them make measurement in my presence. That is my prayer also, Lord.
After 2 years.
Because Lord, I have disputed their measurement also. In my Annexure 10,
2024.
I know common.
He is saying that they are not giving.
Measurement they are not
They are not
communicating.
giving.
They are not communicating. I have called for also.
Then when they have called you in the office,
Lord, office in the 25/11 and 10/12, 2 days.
and to be requested
25.
to the office
Yes,
on
sir.
5th January. And then he's been told that therefore you are hereby requested to attend this office on 7 January 25.
No, no,
Clear an aim for accepting the final measurement for further course.
so that 25, nearly one year has elapsed. What you were doing?
And you filed this writ application in November 2025.
Why after such a long time?
No, they supply the copy. But I have filed also. That
Where? They have supplied you in the month of January or December 2024.
thereafter
Why you
I-
did not? You raised objection.
Number of occasions, Lord, I have approached.
No.
9th January, Lordship kind of.
Then I am reminding you of the Supreme Court judgment that frequent filing of the representation does not really.
Not that frequent. 2-3 letters are there.
Why?
One letter is
Why
that
you did not?
it has been stated that behind my back measurement has been done.
Then why
And you have
not?
made
Why
wrong-
not you attend on 7th of January and raise this object?
9th January I have given. 9th January 2025. I have given the letter, Lordship, I have glanced and accepted.
When the date was fixed by them.
They fixed Lord 7th
So
7th January.
what you did?
For acceptance, Lordship. For acceptance of measurement.
Also, you could have
Because I
read and say, I am not accepting.
Not because Lord, I have disputed the measurement.
Sorry?
That I am not accepting also. That's if they made the measurement in my presence. And Lord, what they have done, they have seized everything, Lord. From the site, they have seized without any notice, nothing. My tools and my machineries have been not seized. That also they are not returning also.
Yeah. What to do?
That also that the measurement inspected and taken by your staff was found to be wrong. He has no knowledge of the measurement. How can he say that it is wrong or right? There's some documents that are missing.
How do you know that what is the measurement? Since
Look, I have said behind me.
oh,
First line is Lord, in the first paragraph.
that is what is taken behind your back, but it was communicated to you that this is the measurement for which you say is wrong. How can you say?
I have stated that measurement has been taken by your staff was found to be wrong.
Correct.
So-
How can you say found to be wrong unless you are given a measurement?
No.
Now they have said 1500 square feet. You say found to be wrong. So 1500 is communicated to you.
The petitioner
Ah,
has written.
so easy.
The other partners are also there. It is a partnership firm.
Yes.
Anyhow,
Lord,
we are liberal. We know. but last gasping resort. Give.
Lordship, in order for review, motion.
Yes, isn't it? Will you small father? We are not going into certain other aspect.
No, the other aspect, that is the subject matter of another reading. Only in this.
Also, in this also, we are not going into the other aspect. We are just keeping our eyes to some extent blood.
Display. Display.
Release the practical also.
Item 15.
That's great also. Let them release the. They have not given also the.
If the liquidated damages is to be recovered, what from where they will recover?
That is not decided. No. Now
That is not decided. It is for that. No, can't be.
15.
Just line that since we have simply directed him to make a final measurement in presence of the petitioner, the other prayers shall not be deemed to have been entertained by us.
That is the only prayer, sir, that he wanted. Release. That is the only prayer.
That's the only prayer for release.
Two prayers, sir.
Just to avoid res judicata, we wanted to save.
No.
What is two prayers?
Issue notice to
Final
after hearing. Which of madam was directing the opposite parties to make final measurement of work so and so.
Okay.
And release the machinery.
Both yes. So one we are saying,
In
other prayer
presence-
will say we have not decided and will not be treated to have been decided. Yes, call the next.
Item 15.
Yeah. The petitioner's tender almost fixed number of tender have been rejected without assent. These have been rejected on technical. My tender paper was rejected on technical ground. And next 4 years I had approached. 6 number of contract actually tender have been cancelled. Earlier I had approached your lordship and gave a glance on similar grounds. And this order was passed after hearing the state council and it's a 7/6/2.
And it's sure.
Department, same nature of work. But here, only difference, they have not communicated the reason of cancel. There it was.
Why you are not communicating the reasons? I think rather this bench has in many cases as says the reason is indispensable. So why will you not provide what is the reason for rejection? How do we know that what has gone against him? I think so many judgments we have caused and says the reason has to be provided.
Their occasion of the ground provided and challenge.
Yes. What? That even without reason, order can be there. Huh?
With the grounds of rejection and the tender committee.
Give him a copy. It is in communicated.
This is the entire writ petition that solely basis.
So based on that, you have not submitted the reasons.
No, my lord, the 4A is the reason of the entire writ petition. And
4A, your lordship,
reason-
it's Annexure 7. Annexure 7 is the order your lordship passed after giving them hearing, giving them a chance of hearing. Same ground, Annexure 7 is passed, your lordship. The matter is pending. There are 6 tender have been rejected. This is the first
Good.
one your lordship passed the order. 6th one. Same authority, similar nature of order. Similar treaty, same petition.
4A.
Annexure 7, page 61. Yes, 4A, ground is 4A. Now he has come up with that, similar thing. But in this case, it was not communicated.
This is the same contract.
Same contract, same contractor, same authority.
But my lord, I'll take this 1 minute, my lord.
We are permitting him to withdraw and file a fresh petition covering the entire ground.
If the grounds have.
Or there is no order which is this order?
Second document which I submitted, my lord, the technical evaluation committee.
Yeah.
These are the proceedings.
Have you amend and challenge this?
Yes. But same, I have taken the ground.
No, whatever, you challenge this. Keep on legit. Or to withdraw and file the.
This made this still it's next year, my lord, because the work season, my lord, if the fellow stays, then the work season will be available. Only that reason.
Next picture, next.
Item 17.
What's Yes, what is the
Item 17.
The opposite party, higher education, Government of Odisha.
where is the 2711 order?
Annexure 4, minute.
Where, which page?
Page number 56.
Yes, you have not submitted the income tax return for 3 years.
Well, we have not submitted, but lab.
And also the balance sheet.
Yes, my lord, we have not submitted. That is already in technical evaluation matter that was been that was already discussed matter. But they asked that after submission of PPT, they will ask for deposit. They allowed lab excellency, one of the betterment.
What?
To file one of the documents.
Show me the tender notice. Tender call notice.
25, page number 25, annexure 1.
Is it mandatory?
Yes, my lord. All are mandatory.
So, why?
My lord, clause number 15, there were so many mandatory documents. In clause 11 also, in 15.11, there was also list of course material. Page number 37. Page number 37, there is 11 mandate. list of course material, also submit one set of material. This is also mandatory. La Excellency, one of the bidder. Well, there is two types of study material. One is general study, one is for general studies, and another is optional subject. General studies, for general studies.
Are you challenging your rejection order or you are challenging of the successful? Sir, you are challenging your rejection order, and from the rejection order, it appears that they have correctly done it. If the conditions are imposed that you have to submit, if you do not submit, then what is the wrong in them?
Well, there's the arbitrariness.
What arbitrariness? They say that you'll have to submit the income tax return ITR for last 3 financial year. You did not submit. They say that you'll have to give the balance sheet of last 3 financial year. You did not submit. What is the fault the authority has done?
That is
position that there is no fault.
that is my submission.
What submission?
This is
Did you submit it? Did you submit?
no, at the time of technical evaluation, I have not submitted.
Then
They did not allow at the time of opening the technical bid.
that you will subsequent there too.
No,
You have to do it
They,
at the
they said that after PPT presentation, they will allow me to deposit
what deposit?
the IT return and final.
No, then what is the tender condition you have shown? Page 37. Where is? Page 36 and 37.
Yes, madam. Technical bid mandatory documents to be submitted with the technical proposal. Bid envelope number 1.
Bid in, there are 2 envelopes.
Yes, ma'am.
One is for technical and another is for financial.
Yes, ma'am.
So when it says the envelope number 1 means at the time of submitting.
Number 5.
Yeah.
Item number 5 is mandatory.
My lord, this is mandatory.
No, what he's saying is that at the time of opening of the technical bid,
That case.
then he will submit.
Sir, no.
No, sir.
No, my lord, that is not my submission.
Huh?
My lord, there is in 15 clause 15, point number in point number 5,
Five.
tax returns. In point number 6, income expenditure.
Correct.
In point number 11, one list of course material.
Yes.
There is the cross.
What cross?
Cross
They
is
said that you have
allowed-
submitted
They
it.
allowed another bidder material.
Sir, you are
submit.
not. Sir, again, I am asking you a question. Are you challenging in the instant writ petition your order of rejection, or you are assailing the choosing of or declaring any person as successful on that ground? You have to choose one. Tell us what you have chosen.
My lord, I have in my trailer.
You have challenged this rejection order. That's why I am putting a question to you.
That is also and opposite party shall not directed to reconsider bid application for reconsideration.
Why? What is the wrong in them?
Because they consider another bidder, my lord.
Arre,
That is my submission.
Sir, to reconsider the bid application of the applicant means you.
Yes, ma'am.
So why? What is the wrong in it?
Oh, but you may be
Some other person and they did not allow me. That is my submission, madam.
Sir, we have to go by the plan. We can't do. What you have done, and then we are discussing. Look, it
18.
First paragraph, you refinish.
Right.
1J,
Yes, sir.
which page?
Condition 1J,
Which paragraph?
page 22, my lords, 1J.
Yes.
They should have a minimum average annual turnover of rupees 10 crores during the financial year, such and such.
Yes.
My lords, if your lordship kindly sees page 19,
Yes.
the approximate bid cost, clause 5.
Yes.
The approximate bid cost for 1 year is 2 crore. exclusive of-
You come on Monday. I think the similar matter, I'm in the process of dictation. So it is better that will abide. You just go through it and then it will be delivered in this week. Come on Monday.
Item number 20.
Yes.
Item 20.
That's the order. That's the order.
Yes. So notice
Can have page 36.
what?
Page 36 of the bill.
What?
This policy of India introduced by the central government
In 2000?
2022 of Cabinet Committee of Economic Affairs. Lordship kindly have that first.
Yes.
Yes. Now this is being amended by the CIL board. It's a company now. Like the Ministry of Coal, with the approval of Cabinet Committee on Economic Affairs, has framed the guideline for e-auction in 2022, based on which the auctions were being conducted. Now let's see that at page 35.
So we have to issue a notice and then.
I'm just trying. Interim order. Because
What
of
interim order?
This is on every fortnight there have been several auction being conducted, and we have been deprived of.
No, we can't stay the entire auction. That no time it will be. Or to restrict or follow this particular mandate of 2022 scheme.
Clauses that says that whatever I will purchase, I cannot take. Whatever they will give, I will take. That's the case.
No, I understand.
Well, that's all.
I understand.
So that's the.
Come in the, yes, what do you say?
Yeah, I have to take instruction.
Take instruction.
Yeah.
Sector is listed. This.
No, that is not.
No, it was supposed to be listed on 1st December.
And it was on board, but could not reach.
Come on the next Monday, both the matters. Bring it on next Monday.
Face admission.
Just and issue notices on everybody. You are representing?
Central Union of India.
So other Coal India Limited, serve the notice, give a requisites today.
The coal pits and
I just want to.
Give a requisites today.
Yes.
All the things.
Item 21.
I just paid Monday.
Yes,
Face
sir.
admission.
Next. Oh, it.
21.
Demand notice of the annexure 8 from page 108 to 11.
Yes.
So the demand notice
at page 108, if you want, it will just have a glance at it. There is the impugn annex, which has been made, Lord, for a period of my mining from June 2016 to March 2020. And it has been issued on 29/9/2025.
Yeah.
On the ground that I didn't have the CTO.
Huh?
The consent to operate, though I had the
Yes.
consent to establish or
True.
the environmental
Correct.
clearance.
It's a Sariyat.
Yes. And though the requirement is that I should have an issue and CTE, but CTO was never, whether it has been insisted upon during the period of operation. I have paid the royalty, it has been executed, and after 5 years, they have raised the demand.
Why not? Why not?
I'll just take your lordships to the notification. The gadget notification, your lordships may come to page 98.
Yes.
There, my lord, this for minor minerals, which is below 5 hectares, in the bottom, my lord, tablet form. The requirements.
Mhm.
The EC is required. Then, Lord, on the next page, I think above 5 hectares. So here, my lord, I have the CT. The CTO was not there, neither it has been insisted upon during the period of the mining lease. My mining plan was there. I paid the royalty, I have lifted the
But
material.
now this, because of this 2017 judgment has come in a common cause. What to do? They say consent to operate is to be issued by the state pollution control board is
My
mandatory.
mining plan is of 2015.
Maybe it has overridden the EC and the consent has overridden the mining plan. That is what the constitution been said.
Look,
What to do?
we understand
And this
that-
is from 2000 onwards. What?
So the entire amount, what he might have mined by
But that has to be paid. 156.
No, that I understand.
That has to be done.
We have also cleared in some of the cases.
So
But the question is,
what to do? The Supreme Court mandate has given
minor
an
minerals.
EIA of 1994, then EIA of subsequently 2000. That has come, and the EC
No,
and the consent to operate. Consent to operate is important. Both.
The consent to establish is there. The
No,
EC is
consent to
there.
operate from state control board.
That, my lord, I'm just subject to your lordships.
No, sir. What to do?
Here, Mamita, this is instruction that even we had asked at that relevant time for CTO. That is a letter of 21/10/2017 and received a paragraph comment in this matter.
17.
Yes, my lords. This
No,
letter also.
Page 33, I think if my learned friend is speaking about, your lordships knows.
Letter of 21/10/2017 I have received my.
Age
33.
Which date?
21/10/2000.
This is page 33 of the.
Of the writ petition itself, I have enclosed that to it. It says CTE/CTE.
Both.
Doesn't say both.
Which let's.
Language is the main major factor. It is a major factor.
This demands pursuant to a CAG audit or recovery matter at page number 1.
Madam, your 2017 letter talks about when you use the slash in between two words, then it becomes an optional, either of them.
That is requirement under the law, my lord. Page number 124, my lord.
Why you have got the letter on 17? You are referring, you have got such a positive instruction. Now this says that it is absolutely wrong. And they have CTE.
It's here because my letter and this page is not visible, my lord. Which was the line.
It is quite visible. You have been given a thin copy. We have a voluminous one. That's why voluminous is a thin copy. Your office has not printed fully.
Yes, my lords. It talks about consent to operate also, my lords.
In between, there is a slash. What is the F?
In both
No
the
answer of-
paragraphs. In both the paragraphs.
And it's in the second paragraph, what I can read is you're directed to obtain consent to.
Established / consent
That is in the
operate.
bracket. I don't know what is the written, because even the paper which I have also is a very bad suggestion in this. And also, my lord, this, if I may just refer to page number 124, my lord.
Seven lakhs on.
Deposited. What is this?
My lord, I'll deposit something subject to your lordship's consideration of this. My lord, it's not the only case where the.
Have you seen the subject of that letter of
Yes,
2007? Where slash is used?
No, that is there.
Yeah?
And even in the third paragraph, and is used. Whatever I could use from this paper, my lord, this no slash.
Third paragraph slash.
In the bracket, there is slash, but the
What?
line,
No.
you are directed to obtain consent to.
Consent to establish slash.
And
No, not that.
Slash.
my lord, there is a space in between. That shows it is an and, my lord.
No,
Slash.
you are carrying something else.
That is what I.
Are you at space?
The space does not permit and to be fitted.
This is.
It will only permit a slash to fit in.
At that place.
Yes, no, this is a better one.
You can.
This is a better one which we have. The space between establishment and consent cannot fit in and
This
under no circumstances. Third paragraph.
Underline where I put my words.
What?
That as a first
Underline.
paragraph, underline portion in my words. That is.
For an officer of the court, when two words are conjointly used, one is the consent to establishment
Consent.
and consent to operate, then you cannot put something that is the establishment cannot come. Not expected, never. Consent to establish is very clear, and then slash consent to operate. Give my copy. Give it to her. Third paragraph. The gap between establish and consent is so thin that and cannot fit in under no circumstance.
This demand is pursuant to the CAG report, matter that page number 124 is the relevant portion, wherein the direction has been issued to all the tehsildars.
But the difficulty is the common cause is staring at our that's staring at.
Otherwise, we would not have.
That position would have been different, but
Because of their letter itself, we went ahead, did it, and. after 5 years,
no, I
they come
understand,
back
but I think common cause came in 2017 itself. What is the date? Date of the judgment
Date of the judgment, we will have to.
by Justice Lokur.
Justice Lokur.
2nd August.
2nd August 2007.
This was the outcome of that. Correct. So after August, this was in October. So that was a fallout of that. They may have committed a mistake, but the clear No. Deposit. Come with a better case next time. No. Just give it to us. We'll just record it. We'll record it. Common cause judgment should be given to us. 2017, volume 9 SCC, page 400. Yes.
Today's item 5, it is annexed.
Item 22.
Milord's, am I audible, Lordship?
Yes.
Milord's, I'm appearing for the petition in item 20. Milord, this is similar to the matter which was there listed before Lordship today as item 11, where Milord's, the rejection notice has been challenged. This arises out of the same tender and the same bid, Milords. Of course, the rejection is on different grounds. Milords, in my case, what has happened, Lordship, is that, Milords, I had participated, I have given all documents.
There is a service has been
Service
affected.
has been made, same point. In view of AFCONs, they have to implement the L1.
Implement the L1, madam.
Milords, we'll implement L1. Lordship, may issue notice, Milords. They've given me a counter at 2:30 in the afternoon, Milords. Lordship, may issue notice.
5 days we could prepare the
L1.
counter.
I have no difficulty. Milords, I'll take permission
Well, the 12th read petition was served. We are ready with the counter today.
Have you served?
Yes, served.
Milords, today at 2:30 they've given us.
How quick could it have been? 2 days. Friday evening, my friend got.
Yes.
No, Milords, today we received the counter.
The writ petition is at the behest of already said,
Already issued.
issued, you implead them a party first.
Malad, I
Item
believe
23.
the lowest
Yes.
bidder has been declared, Malad, but to the best of my instructions,
No, they have also issued a LOA. You have disclosed.
Can this be the reopening week?
This is a reopening 12th. 12th.
would Malad fix
Item
a date?
23.
Please, Malad, appearing in 23, Malad.
Malad,
Very short.
date fixed in item 20.
Yes.
Item not 23 calls.
Yes, short issue, Malad. Just draw Lord's attention, Malad, state account page 17. So this issue,
Have you gone through our judgment which we have delivered in the meantime?
yes, Malad. On 3rd of December, yes, Malad.
I do not know the name.
Malad, the name I know, Malad. It is Maheshwar Behera versus State of Orissa. Maheshwar Behera, Malad. It was delivered on 3rd of December 2025.
Yes. Malad, it's Maheshwar Behera and Maheshwar Behera versus State of Andhra.
So this is a simpliciter writ petition on the ground of recovery of money.
Malad, not recovery of money, Malad, approval of deviation. But they approved deviation.
Your
Malad,
first prayer to the writ petition, kindly see.
My lord.
At page 11, please look.
Direct opposite parties department to release the outstanding payment for executed deviation quantities.
So simpliciter recovery of money. Second is interest.
My lord can just direct them to consider my deviation and make the payment. That's all, my lord. I don't want to enter into any cantankerous issues, my lord. And
Yes.
this admitted fact is there, my lord.
No. If they have admitted the dues in my judgment, in our judgment, we have said that if there is an admission, then the court has care. If it is disputed, then simpliciter.
The principle they have agreed. There can be dispute on the quantum of amount. Therefore, I will say, my lordship, please don't venture into the issue of quantification. But principally, they have admitted that yes, this is payable.
Where?
So, my lord, para 17, page 17 for a moment, my lord. 17 and 18 only, but 17 last para, page 17
Yes.
last para. Further, the second interim deviation statement has been submitted to higher authorities for necessary approval, and the amount will be paid to you as per available of the funds after necessary approval of deviation. So they are recommending approval. Then my lord would see the next page, 19.
Yes.
19, my lord, item A, approval of deviation, and my lord, the last line item A, all the balance amount of the deviation amount already executed will be paid after approval of deviation, which is presently at engineer in charge. So, my lord, since 2024 April, now we are in 2025 December, my lord. So let them, my lord, whatever is the deviation, my lord, let them pay.
Yes. What? You consider take a decision and communicate whatever. Take a decision. We are closing our eyes to the technical aspect. We would have dismissed it here and now.
I'm deeply obliged. I'm so sorry.
Anyhow. Yes. Take a decision within a short span of time. Yes. 4 weeks. 4 weeks is enough? 6 weeks. I expected 6 weeks. So if I say 6 weeks, you will ask for 8 weeks. So always reduce. Yes.
Item
6
20.
weeks.
24.
Demand is at Annex 4, page 46.
Yeah.
Page 46, Annex 4. My entire case is, they give me a show cause notice. I reply to the show cause notice. They, leave apart dealing with my reply. They have not even mentioned it in my in the demand notice. May kindly have your lordship's demand notice at Annex 4. Page. The demand notice. They have just repeated what the show cause notice was, my lord. My reply was in Annexure 3, page 41. I have categorically given that this is what is how I have paid it. You made assessment orders. I waited for your assessment orders. Assessment orders was communicated to me, and then I made payment. But they did not even consider their own assessment order. Did not even consider my reply, and I mechanically passed this demand notice. Lordship has the demand notice annexure 4. My lord sees the demand notice does not even refer to my show cause reply, the grounds taken, why have they been rejected? Nothing, my lord.
Did they issue any show cause?
Yes, my lord. The show cause notice, my lord, is an annexure 2, page 35.
Yes.
Annexure 2, my lord, page 35, your lordship sees the entire question is on. They're asking.
Then reply was given.
My lord, reply, my lord, may kindly see the reply, show cause reply is.
Yes, will you not?
Yes, no. My lord, may permit me to take instructions in this matter. But
Yes,
this
yes.
is a short date, my lord, I'll take instructions.
When you were served with the copy?
Copy has been served.
This was served on 8th of this month.
Today?
Yes, my lord. 8th of this month, my lord.
And today?
Today is 15th, my lord.
So?
Unless it's a short date, my lord, I'll just find out what the factual aspect is. There are.
Any course step you can't ensure, otherwise we'll have to stay this.
For your lordship's consideration, my lord, because the amount is not much, I'm ready and willing to deposit the entire amount subject to my rights and contention and my final outcome. My lord, because it has got, what happens is the lordship knows in a lot of matters, if there's an interim order, they react, they look at it differently, then they say, I'll not give this, MDCC, I'll not give that, I'll not give a clarification. To bring a rest to all that, I'm ready and willing to deposit the entire amount, subject to the final outcome and subject to my rights and contention. The lordship have any problem.
The No. We'll consider it on.
That's it, otherwise,
Come on virtual mode.
I'll come on, but tomorrow.
Virtual mode on 22nd.
Item 26.
20 seconds. Virtual, I'll come.
Item number 26.
Yes, 26.
Bring your lordship a quick note about the matter. In a tender process, an ineligible bidder is classified as L1. Ineligible bidder, I say consciously ineligible bidder. If your lordship will look at the tender process, it's a three-tier system, and your lordship would kindly see page 720 of my brief. That makes OPWD code applicable in the tender affairs. If your lordship would kindly click over to page 720. Yes. Well, I'll just show you lordship 2 pages. That's
So
all.
your only ground is that whoever quotes less than 15% has to be thrown out.
That is in fact the
And according to you, he has quoted 18.76. That's the only thing.
That is open and
Other side,
that's the open and short part.
that's all. Other side, straight away, the point is very simple. If there is a prohibition, matter ends. Then how can you award a contract below 15?
Yes.
Here, what happened, Miller? I have to take instruction in this matter.
I understand. That is the very recurring feature.
So you're not shared about that.
My predicament is that, Miller, we received the copy of 11, Miller, at least 72 hours.
72 hours.
48 hours is the 48 working hours. I can hand over that rules to you of the another High Court.
Your officer, the additional government advocates, Lok Adalat said that an officer works for 24 hours. Don't sit.
Anyhow, you want a day after tomorrow? Though it is a tax day, but supplementary list, day after tomorrow.
Tomorrow, 17th.
17th is for hearing day. Yes, you come on 17th.
So,
Yes.
27.
See, what?
Second,
That is what you say. 10B.
10. So he's saying 10, deposit of 10.
Next.
Item 28.
We have privilege. You are also in this case, the person is challenging an assessment order initiated against the petitioner, and it's a wrong assessment order, and the work executed by some other person having this linked to this petitioner.
Oh, how can you?
I have taken instruction.
Wrong.
Yes.
Correct. Rectify.
In 21 assessment order.
Somebody else.
In 21 assessment order was passed. In 25, the concerned work division has clarified that he has not received the payment,
So,
and we have also cross-verified. Last page, Lordship.
so it has to go. Yes. Disposed of.
Nine.
Wrong name, actually. Wrong assessing.
disposed.
Similar matters has been disclosed. If I do similar issue. Direction was passed. The officer in charge should take a view in view of the admissions need. Same petitioner, same issue. In the meanwhile, the concerned person has again sent it to the up to the senior officer.
This is what we have done.
Yes.
Same order has to be. Both.
29, both the cases.
The only prayer was
Opposite file number 2 may be directed.
Maybe
Opposite file number 2 may be directed because 3 has in the meanwhile approved. So 2 may be directed. That is my only prayer. You know, that will suffice.
Connected.
concerned opposite party. Just
Much. Very good. No. Much.
this dictated by me. We have included what is dictated from the house.
Item note 30.
So the was it is
Trader of iron.
Yes,
Petitioner here is a trader of iron ores.
is a
Trader, iron ore trader.
trader. Okay, trader.
Like, the Odisha Mineral Development seller, which has sold us iron ore and accepted money, the Lordship will see, is 19 plus 2, 63.74% of the grade. I don't know, they have sold us. This is our property sale order. Lordship will try to see page 90.
Yes.
But the grade is at serial number 2. The price is quoted just last but 2 lines.
Yes.
Please arrange to remit 2 crore 28 lakhs 10,777. Now this is the sale order. As per the sale order, we paid them the amount and lifted the matter. Lordship will find that when we made it grade from the appropriate agency, the agency has reported the grade to be 58.91%. That is page 20. Page 24, last, Lordship will see chemical analysis, 58.91% grade. Of that ore which they have sold it, saying that it is 63.91%.
Yes.
Now, as per the IBM rate, for 58% or below that, there is a price provided. The Indian Bureau of Mines provides the rate also.
Now, what is their stand?
But it's notice is yet to go. They are not proven.
Notice, first week. Yes.
Item note 31.
This is again, Mr. Pandit is not there, your Lordship may permit me. This is again in akin to that IOCL matter in past has been. In a similar, but the difference here is they have in fact after cancelling the NOC, the HPCL has allocated to someone else. But here in the IOCL matters, your Lordship will be deciding whether cancellation is bad or good. That will be virtually covered by your Lordship judgment. But then I'll have to take give them notice, otherwise.
Yes, give a notice. First week.
There's 2 matters also of the consequence analysis, HPCL consequence.
Yes.
all these are some.
Let's be taking up next week.
Next week.
Item 31, I am absent.
Come on the next week, 22nd.
Item 32.
Can I just seek a small protection?
Nothing is going
Thank you,
to.
Lordship.
Yes.
Item note 32.
32. I must rejoin our man. Let it come one.
Was filing a rejoinder.
Already item 32,
Oh.
we are filing counter affidavit today. I am solving a copy.
Oh, he is not there in the matter. He is not there in the matter. Okay. So you are receiving a counter. You file a rejoinder, how much? Well, copy whereof has been served in the court. Raise for filing a rejoinder. Rejoinder at 12 matter. Yes.
Item 33.
Lordship, personal Lordship direction. I have filed a copy of the Lordship NGT. And I just like tried on the remaining period which has been stayed by NGT. That's why Lordship, that only mining officer can take a decision. There are 2 judgments, Lordship judgment and Lordship another. It can be disposed of the direction to mining officer to take a decision, Lordship. Both the judgments are there. Your Lordship judgment in Suraj Sagra, I was there also, Lordship. It is directed to manning to take a decision. In other judgment, direct judgment, let's say, Jayaram Das. During pendency of the issues before NGT, and operational period has been extended, Lordship, to.
No, that was a very, very important decision where the petitioner was neither to operate in the morning nor to operate in the night. And he was, you argued, I believe, only 2 hours or 3 hours.
So that doesn't have benefit.
That is a Suresh Jaiswal.
Suresh Jaiswal. And other judgment of Jayaram Das, it is squarely applicable to me because of due to interference of NGT, intervention of NGT, I could not operate. Only finding up.
I think there is one matter also there to.
Finding up should take at this one, he can.
This
Yes.
Pamirath was arguing that.
Yes.
Item 7, Lordship, item 7.
Yes.
Baleswar.
Here is the Baleswar, Lordship.
This one? No. This one you have punished. Panjamahal stone case. आज एक केसটা কে করছিল?
What has happened in 7?
Monday, Lordship.
What has happened in 7?
Monday. It's coming. Monday.
So let it come. Oh, he is moving. Do it day after tomorrow. You take instruction. He is moving up, so that's why. Yes.
Item 34.
Yes.
In this case, we are highly confident of the
Just a minute. WDG is having A-class contractor license.
He's filing a counter. He will be relying on those documents.
I am anxious because
I understand. Will you file for what?
Listen.
Will you file rejoinder?
No, I'm anxious that interview is going on. Unless there's an entry model, it will go infructuous.
You want to file rejoinder or not?
Not gone through this.
So go through it Monday next 22nd.
Yes.
We are keeping come on 22nd.
agreements are actually have already been signed.
Whatever, we'll see to it.
Item 35.
Where in the case was also they confined the bid to the Bhubaneswar and Kottakas.
What is that?
No, there is a condition in the bid that the participant must have a rest at Bhubaneswar.
There is a special reason for that.
Yes, Miller, they've given a reason. It's only basically for coordination purposes.
So,
coordination purpose, similar case, they have given tender and given supplied with coordination matter, get a difference, different separate. Why it will be denied to the other person? Why?
intelligible differencia. He has taken a plea. Classification within a class. That is a point he has taken. What to do? To answer.
They have stated that there are two particular officers they are stating, those two officers situated in Bhubaneswar. And those two officers are very similar, they have to monitor the whole issue. So because that petition is situated at Balangir, which is quite some distance.
And where is the printing material to be done?
That is at Bhubaneswar, Barmunda, Bhubaneswar.
Where the printing would be done by you?
Balangir.
Why?
Balangir.
If they want an inspection, then what to do? Do one thing. You participate in the event it is granted. Their travel expenses will be borne by him for inspection. No difficulty. You bear the travel expenses. Ready?
Travel expenses, travel expenses, how university, they have not given any reason. Why the other district will not be participating?
Because they not monitor this printing requires the approval of the designing, some changes, constant sitting, everything is to be done. The mistake is to be checked.
Yes.
Then what?
We are just a statement, they have given, let them file an affidavit at least.
File your affidavit, it will be beneficial for you 2 weeks after. Yes, next.
Item number 36.
36, please, my lords. It is like kidnapping case, my lords, from
Yes.
point of a minor child.
Hey.
Single judge. But my plea,
Yes.
here the respondent number one was the petitioner.
My jealousy is not well today. So if you're
Who?
see SP.
He's not well.
No. It's suffering from cold.
May I one prayer?
Next. Monday.
No, one prayer, my lord. May I take notice to other respondents in the meantime?
Take notice, then it's better 1 week after that.
Yes,
Well,
After.
2 and 5 government will take.
Yes.
The AGU will take.
Issue the notice on those.
And 3, 4, I will file it with you.
Yes, 38. 8.
Lordship and for the payment of the Lordship on the last occasion audited 11/11/2020, the Lordship had asked us to serve the copy upon the council for opposite party number 5. Filing a memo to that regard. We have served the copy from that.
Where is the affidavit of service? Must have been written that you will file the affidavit of service. This has to be shown by a person who has lost that particular service, that I have personally gone there, 1 paragraph, 2 paragraph, and say that I have done it. I am not groomed in a memo, the arena, or I have not groomed. I am always on a court record, must be supported by a verification. File it. If they come out, at least you are responsible for the affidavit which you have done. Sorry, you'll have to file it. Yes. And issue notices. No, not issue, just file it. Affidavit. Next.
Item 39.
Yes. Caveat is lodged where? Huh? Yeah.
Put a question to counsel for the respondent. Referring to para 3.1 of the order passed with the honorable single judge.
Yes.
The honorable single judge has referred to a letter.
Fairly considered.
Yes.
It is fairly contended.
And the honorable single judge has referred to a letter which was produced before the court.
Correct.
So your lordship had put that question that
Where is that letter?
if that extension is
Sir,
granted, then
where is the letter?
Copy of that, I am going to appear in the case in one of the cases. If your lordship permits me.
Sir, there is a reference of a letter dated 2025.
Yes, I have got a.
Just give me that. What is that letter?
That letter is extension of the CCR.
CCR. Whatever. That is what I really wanted. Yes, that is correct.
yes, madam, that is incorrect.
No, this is what is letter.
That letter, yes, I have also
Give.
I have also obtained instruction on the same letter. Lordship finds.
Yes.
Here they were supposed to give their property details through online mode.
No, I understand, sir. It was the only question was the learned single judge said that once it is extended to 26/9, it must be online, it has to be filed. But it appears that they have also filed offline on 20th of September.
That is
prior to
property statement. Here it is. This letter refers to the CCR. Issue is with respect to submission of the property statement.
Oh, CCI means what? CCI.
CCR. Confidential character.
Confidential
Character reports, and the CCRs are already available on the online mode. Part of the CCR which were not available, only those portions were asked for.
Give me that letter. That letter of 26.
Intent to stay.
Yeah. Oh, they have been closed.
Yes,
Yes.
yes.
Oh. Oh, the learned judge was of the view, since it is to be submitted by 26/9. So now they have already submitted on 20th. So you consider it and then submit the CCR.
What?
Yes. The issue here was that he got for promotion because
Earlier, if I can be permitted to submit, but the entire issue arises out of non-submission of the property statement. For the what is
Sir, there was a sufficient notice which was given to all these officers. Many a times they were given, they did not submit. When they found that their promotion would not be given, suddenly they woke up and then filed the offline is not there.
No, the offline was with the leave of the court. Court directed to submit offline. That is in the your lordship will get it in the read petition. That is.
but you get may
Yeah, your lordship will get it that batch of.
Your senior is there.
Batch of cases.
He's in another matter.
Yeah. Same
batch.
Tag to this.
One of the.
Your writ appeal number, sir?
It is writ appeal number. So this Kavita Naik.
Yes, second one, 1602. 1602. Third is appearing in 1602.
So that's it. Then along with Sadashiv in the case of Kavita Naik.
Okay.
Yes.
So 1602.
1602. Yes, sir. Okay, so in that case, if your lordship goes through this order, as your lordship got the earlier order of 26/9/2025.
No, we are concerned with the impugned order.
That was disposed of in terms of this judgment.
Give me that.
by enter submission.
Oh, Anantanarayan Naik. That case is followed.
Yes.
That case.
That
is Annexer 5. Annexer 5, page 49.
Yes.
It is annexed.
49, page 49. You are seeing
No.
1602.
No. This is 1672.
1672.
1602.
No, 1672 writ petition টা বার করো। 27510.
Yes, ma'am.
1602 disposed of না হচ্ছে।
No, open it. Sure.
Same replicant.
Oh, this is a
second
sub item.
No, page 40.
No, 49.
Sorry.
No.
The same
So you
order.
can get,
The same order.
Because council is same.
Place that on.
No. It's a different.
No, this is followed in those cases. This is disposed of on 20th September. So subsequent cases have been disposed of following this.
That seems to be in the English mistake in construction of that sentence.
Court's order was absolutely staring at your face. When you have given a promotion,
When it has not been given as yet.
no, they say the promotion has already been given on the last day. When subsequently, how can you give after September order?
No,
Then you
you have
can't.
allowed only petitioners. You should have allowed everyone in the same spirit. How can you discriminate? Those who have approached, you have given, it's understood. But you should have allowed everyone.
No, he has not given to
Those who
them.
have submitted their property statement to online mode within the time frame, they were considered and they have been given promotion.
But there is a direction on 20th of September to comply.
But that is subject matter of challenge in the writ appeal.
So how can you give a promotion subsequent to this order?
Promotion given on 10/10/2020.
How can you after 20th September order? Question is this. Is it not a perceived contempt?
They understanding that they have proceeded in writ appeal.
You knew that in 20th September the order is passed. When you file all those writ petition, the appeal, when within 10:10 or after 10:10?
This Ananta Charana Nayak was filed on 9/10/25. Records shows. This Ananta Charana Nayak where the order of the Honorable Court. There.
Then on 10:10 you have proceeded.
That order was not challenged.
That order?
Yeah, challenged.
That is on 9:10.
There is the third case. All 40 cases.
Oh, these are all
two different orders.
One is 26/9, another is 29. No, we can't do it. We can't. These are all, your conduct does not really instill a confidence.
Subsequently.
That is the whole problem. When you knew that on 20th of September, there is already a direction which has been passed, and this order needs to be challenged, it will impede the promotion to be given because they have to be considered. Have you considered them?
Because
you have spared them. Have you considered and then found that they are not educationally, knowledge-wise, merit-wise, not eligible?
Submission of a property statement is a precondition for giving promotion as per the rules.
Sir,
since it was
Mr. Das, probably you have not linked the wavelengths. I am not at all saying that this is not a condition precedent. It is a condition precedent. When the court found that whoever has not filed, he will be able to, if he files today, that is on 20th of September. If he files, then he will be considered
And on the one hand, you have.
What more?
No, they have asked for the stay of operation of that order. You have filed IA enclosing in with the writ appeal, and considering the thinking that it is it tantamount to stay. And you have proceeded.
Para 6.1, the Honorable was directed to submit the property statement offline mode, which is contrary to the.
Sir, with deepest of respect, probably I am not been able to convince you. You would have been a very tough judge to me if I am there. Please try to understand. There is an order, wrong order, illegal order, or whatever order is staring at your face. You can challenge the order by moving a higher forum. But can you contrary to that order or to nullify that order? Kindly consider it. The amount of risk you have exposed yourself. Do you realize? If you filed the appeal on 9th, what was the occasion to act in haste on 10th? Very next day.
This is only promotion.
That is what is troubling us. This order is staring at your face. If you say that we have considered him also but did not find him suitable for a promotion, matter ends. No difficulty. Throw them out. They do not have a right to promotion, but they have a right to be considered for promotion if the eligibility comes.
Filed IA tied to this.
This what is really is not appreciable.
The selection board.
And now you say promotion has already been given, promotion, just to create a irreversible situation. This is really an irreversible situation. Put them, all those promotees, at risk. Did you write a promotion that this promotion is subject to the result of the writ petition or writ appeal? In many of the cases, it is done. Have you written?
No. The promotion order.
Have you written that this is subject to the result of the writ appeal?
Yes, some writ petitions have been recorded.
Yes. So we'll decide on that. So they do not acquire any equity in their favor. If they are aware that there is a litigation, then they do not deserve any equity. Is always subject to.
This promotion order has been issued subject to the writ petitions, which are
True, no difficulty.
But whether the case of the petitioners have been recorded, respondents have been recorded.
No, whatever. This Anantanaran Naik is also 161.
No, sir. This can't be done.
The selection board sat on 8/10 and the
Yes.
promotion order was issued on 10/10.
Whatever. Then
In between that.
so, but order was on 20th of September. Is it not? The order was passed on 20th of September, 20. No, sir, this can't be. We have to upset the entire thing. Press exercise, do it. Whoever is entitled will go. Show me the judgment that if the promotion or the appointment is subject to the result of any pending litigation, then in that event they do not acquire a right of hearing in that regard. The court may proceed. No equity plays in their favor. There are 3 or 4 judgments. Find out and give it to me. We are keeping. We will pass this order. We will not include 300, 400 persons who have been a promotee as a party here, just to make it a clumsy one.
So far as those promotees are concerned, that is subject to final outcome of this their promotion shall be subject to panel outcome of this writ appeal. So far as the merits of this writ appeal, that the Lordship may fix up a date so that it can be heard and.
What merits?
This is the only point. For one time only. What? This is one time exercise only.
At 3 occasions they were given chance. 3 occasions. It is not that one time. We are not against them.